Okay, I'd like to welcome everybody to this Saturday, May 29th, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Chris, and welcome to NT Trust Technology. So let's get started here. Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or short recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Okay, we're going over Book 30A of Corpus Juris Secundum, CJS, and we're starting on page 178 under Section B. It says Remedy at Law. The title of tonight's show is Remedy at Law. And I think we're going to back up a little bit before we start there and start at 174, finishing up the section before that under Section 13, which is Trivial Matters, Jurisdictional Amount. And this is under Book in Equity. So the general courts of equity may have declined to entertain suits involving small amounts, although the rule is subject to certain exceptions. From very early times, it was considered beneath the dignity of the court of chancery to entertain suits involving only small amounts. One reason stated to be the avoidance of litigation unprofitable to the suitors and wasteful of the court's time. In the United States, similar rules have been recognized in some instances specifying the amount in which jurisdiction has been made to depend. Whenever jurisdiction is extended to a new class of subjects by legislation, such extension presumably is made subject to the limitation contained in the above-mentioned rule, although it has been held that such limitation applies only to those cases where the equity court has exclusive original jurisdiction and is not so limited in cases of auxiliary or ancillary jurisdiction conferred by other statutes without regard to the amount. Whether the suit is trivial is generally to be determined by the nature of plaintiff's demand, as disclosed by the bill, and not by the relief which he finally shows himself entitled to. Let me state that again. Whether a suit is trivial is generally to be determined by the nature of plaintiff's demand as disclosed by the bill, and not the relief which he finally shows himself entitled to. Next section, exceptions to the rule. The rule, as stated, is subject to some well-established exceptions, and where a bill seeks to establish some right of valuable and permanent nature, or in cases of fraud, or where no specific amount is claimed because of a necessity of a determination by the court of the amount due. So, in a suit to reform a conveyance, the value of land omitted by mistake therefrom, while an element in determining whether or not equity will take jurisdiction, is by no means the controlling and determinative consideration. The omitted land may be of great importance to the value of plaintiff's remaining land, or it may have a peculiar value, pretium affectionis, in plaintiff's eyes. So in other words, the value is determined by you. Next, section 14. Useless or impractical relief. Bingo. Useless or impractical relief. So we could use this one against them. A court of equity will not do or require the doing of a vain or useless thing. It will not have powers to accomplish useless purposes, nor will it grant a decree which does not confer a benefit, which is impracticable as concerns enforcement, which is not enforceable, or which is ineffectual because compliance is impossible. A court of equity will not do a useless or vain thing and will not require to do the vain or useless thing or performance of an impossible act. Even though the court has jurisdiction and will not lend its powers to accomplish useless purposes, nor will it grant a decree which does not confer any real benefit or effect any real relief, which is impracticable to carry out, which is not enforceable, or which is nugatory or ineffectual because compliance within this is impossible. Here comes the bingo. Courts also refuse to grant equitable relief where, if granted, one of the parties may nullify the action so taken by the exercise of a discretionary right which either the law or his contract has conferred on him. I'll read that again. Courts also refuse to grant equitable relief where, if granted, one of the parties may nullify the action so taken by the exercise of a discretionary right which either the law or his contract has conferred upon him. And that discretionary right might be by trust. So nullify the action so taken. But you have to make the claim or you're going to waive it. And let's say what that action would be. Let's say unclean hands. Doctrine of unclean hands. Doctrine of unclean hands will nullify the action of, say, the plaintiff on a foreclosure action. So the courts also refuse to grant equitable relief, say, action for foreclosure, where, if granted, the one of the parties may nullify the action so by coming in, say, with a certificate of unclean hands. That would be the exercise of the discretionary right, which either the law or his contract has conferred upon him. Continuing on now. However, the fact that the court of equity will be justified in a particular case in denying equitable relief by the person of its impracticability does not deprive it of jurisdiction. Next, section 15. Next section. Next, section 15. Legal rights not established at law. I'm going to read that a little different. Legal are not established at law, only in equity. So while the rule is usually otherwise, where law and equity are merged and are considered or are administered in the same court, in general, where the jurisdiction at law and in equity are exercised separately, in order to appeal to equity to enforce the right based on legal title or claim, the plaintiff must first establish such title or claim at law unless the legal right is clear and there is no uncertainty as to the principles of law involved. Now the research note, where it is necessary as a preliminary to the assumption of equity jurisdiction based on the prevention of multiplicity of suits to establish a legal right at law, is discussed infra section 38 through 41. Continuing on, where the jurisdiction of law and equity are distinctly and separately exercised, plaintiff who founds his rights on legal title or claim, which is controverted, must, before appealing to equity, first establish such title or claim at law. The limitation of the rule is that
When the legal right is reasonably clear and there is no uncertainty of the principles of law involved, its establishment at law is not required by equity, will ascertain the existence of the right as well as protect it. Where the legal right is not fundamental but a distinct ground for equitable relief exists, no prior determination is necessary. Where the distinction between law and equity has been abolished and the same court has power to administer both kinds of relief, one resorting to an equitable remedy for the protection of a right or the redress of a grievance need not first reduce his claim to judgment and exhaust his legal remedy by execution or other appropriate process, but the right will be administered and full relief given in one action. Next, section 16, judicial character of relief. A court of equity can exercise only judicial powers and therefore cannot perform an act which is entrusted by law to public officers or control the exercise of powers by them except to prevent an abuse of discretion and to require their powers shall be exercised in accordance with law and in a manner not unjustly injurious to rights protected in equity. Powers which may be exercised by a court of equity are solely of a judicial nature. Therefore, courts of equity cannot perform an act which the law entrusts to the discretion and control of municipal or other public officers or control them in the exercise of such powers, except to prevent an abuse of discretion and to require that their powers be exercised according to law and in a manner not injury unjustly rights protected in equity. Similarly, the court cannot, from a sense of justice or public necessity, do that which properly belongs to the legislature, nor can it remedy a wrong by making in effect a contract between the parties with reference to the subject matter as shown in infra section 61. But my comment is, what about a trust? Now we come up to B, the remedy at law, section 17 in general. The adequacy of a remedy at law as a line of demarcation between the courts of law and of equity is strictly preserved. While the jurisdiction of equity is constantly growing and expanding, the line of demarcation between the courts of law and equity arise from the inadequacy of a remedy at law is strictly preserved. The touchstone of equity is the lack of an adequate legal remedy as discussed infra sections 18 and 20 through 20. And hence the scope of equity is inversely related to the scope of the available remedies at law. So they're inversely proportional. The more equity, the less law, or the more law, the less equity. Continuing on. Furthermore, the line between the law and equity is not only sharp and distinct, but is variable and changing. Where the legislature has created a clear remedy for a specifically identified evil, a court of equity will enforce that remedy. A court of equity cannot exercise jurisdiction over a matter which has by statute been expressly entrusted to another tribunal or adequate power to deal with it. Section 18 now. Lack of remedy at law as ground and limit of jurisdiction. As a general rule, the inadequacy of a remedy at law is both the foundation of and conversely a limitation on equity jurisdiction. Unless legal remedy is made exclusive by statute, generally equity may be stated to have jurisdiction in cases of rights recognized and protected by the municipal jurisprudence where adequate and complete legal remedies cannot be had. In other words, the touchstone for equity is the lack of an adequate legal remedy. To invoke the powers of the court of equity, it has been required that it affirmatively appear from the face of the pleadings and from the evidence that plaintiff has no adequate remedy at law. Where a case presents such complications, such obstacles to the disposition at law, and such questions particular to equity as to make it manifest that a court of law could not so deal with it as to effect a proper adjustment and bring about a complete termination of the continuation, equity has jurisdiction. Continuing on. Conversely, equity will generally not take jurisdiction where there is an adequate, complete, plain, and speedy remedy at law, unless it is shown that there is some feature of the case which is peculiarly within the province of a court of equity, or unless a special jurisdiction has been conferred by statute, or unless it has been held some special and substantial ground of equity jurisdiction as alleged and, if necessary, proved. This general principle has been embodied in some statutes, and its application necessarily depends on the factual circumstances in each case. And in this connection, the phrase adequate remedy at law, quote unquote, has been said to be a legal term of art having a settled and well-known meaning in equity jurisprudence as referable to remedy for damages in a civil court. As a rule is sometimes stated, equitable remedies cannot be pursued until legal remedies have been exhausted, and ordinarily a bill in equity cannot be maintained to obtain precisely what plaintiff can secure by an action at law. The theory that the rule that equity will not take jurisdiction where there is adequate remedy at law is to be taken as indicating the origin of equity jurisdiction and as defining generally its grounds and objects is more generally adopted than the theory that the existence of an adequate remedy at law is constant limitation on the exercise of jurisdiction. Where the latter theory prevails, the court in adopting it have generally been influenced by statutes and terms restricting equity powers to cases where there is no adequate remedy at law, but in other jurisdictions such language in general statutes is held to be merely descriptive of and not intended to restrict equity jurisdiction and not precluding the broader doctrine. The rule that equity will not grant relief where there is an adequate remedy at law applies only when the case stated where there is a legal remedy. A distinction is to be observed between the case cognizable at law, but for which the law has no adequate remedy, and a case can be adjudicated on its merits only in a court of equity. In the one, the equity court is invoked only for a remedy, in the other for the adjudication of the rights of the parties on the facts. And where the suit is properly cognizable in equity, the existence of the adequate remedy at law may justify a court of equity in refusing to entertain the matter. Where the matter is legal in nature, the absence of an adequate remedy at law is necessary to confer equitable jurisdiction. If on the facts stated the case is of a nature cognizable only in a court of equity, plaintiff not to be shut out of that court on the suggestion that on another state of facts he might recover that which would have equally satisfactory in another tribunal. Next section, failure to specifically, well, I have trouble with that one, failure to specifically request equitable remedy. The court has equitable jurisdiction to provide a remedy where none exists at law, even if the parties have not specifically requested the equitable remedy, whenever the pleadings sufficiently give notice of a party's right to relief and demand for judgment. Next section, borderline cases, discretion. It has been declared that the rule that equity will not function when there is an adequate legal remedy undoubtedly controls the clear-cut, unequivocal case, but in borderline cases, the chancellor has a broad discretion in choosing between forms. In doing so, he is not to be such concerned with refinements in pleadings as he is with adopting the form that will give aid to the party wronged. Next section, invocation of equity jurisdiction by defendant. The principles governing the right to invoke the jurisdiction of a court of equity should be held to apply equally to the defendant who seeks equitable relief, as well as to the plaintiff who originally invokes the jurisdiction, as where a defendant does not have an adequate remedy at law. Next section, avoidance of substantial and irreparable damage. If there is a legal remedy available to which resort may be had without any substantial or irreparable damage, one may not seek equity. Equity jurisdiction does exist, however, if the moving party would suffer irreparable injury. Next section, 19, concurrent or exclusive jurisdiction. Where the jurisdiction of law and equity is concurrent, plaintiff is not necessarily compelled to resort to his legal remedy, but it may well be within the discretion of the equity court to determine whether it will assume jurisdiction or the exclusive jurisdiction to adjudicate a matter has been placed by the Constitution or statute in some other court. The Chancery Court is totally without power. Continuing on, the jurisdiction of the Court of Equity is sometimes concurrent with that of the Court of Law and sometimes auxiliary to it. Whenever equity jurisdiction has been once established and a remedy at law is subsequently created by an effect or made effective, and whenever a case is of a class cognizable in equity, but the circumstances render a legal remedy available in the particular case, the jurisdiction of law and equity is concurrent. In such case, plaintiff is not compelled to resort to his legal remedy, and he may seek relief either at law or in equity. The mere fact that a concurrent remedy at law exists does not oust equity of jurisdiction, and even though a remedy at law may be available, the remedy in equity is still proper, particularly where the legislature may give such remedy as being more flexible or better adapted to the particular circumstances than the remedy at law. It has been held, however, that even in this common field, it is in the sound discretion of the equity court whether or not it will assume jurisdiction in a particular case, the matter to be determined in accordance with the circumstances and of the particular case and the relief sought, and that, as a rule, the equity court will not do so if a remedy at law is plain, adequate, and complete, unless there are some features of the case which make it more appropriate for a court of equity than a law court to handle. Equitable cognizance being usually declined where there is a wholly effectual remedy at law, and there are no special circumstances calling for equitable interposition. In the cases of concurrent jurisdiction, the tribunal, which first acquires jurisdiction of the subject matter, may, in its discretion, proceed to a final disposition of the case. When a court assumes jurisdiction, the other court must thereafter not accept to act in the same matter unless good reason to give for the interference of equity. Where equity is involved, its jurisdiction will not be defeated by a subsequent proceeding at law. If the action at law is first commenced, equity will not assume jurisdiction without the intervention of some special cause rendering the jurisdiction at law inadequate, and where the court of law is unable to grant the full measure of relief available in equity. Next section, exclusive jurisdiction. Where the exclusive jurisdiction to adjudicate a matter has been placed by the Constitution or statute in some other court, the question of subject matter jurisdiction may not be waived, and the Chancery Court is totally without power. Next, section 20, in federal courts. In the federal courts, equitable relief is ordinarily justified where there is no adequate legal remedy, but not where there is an adequate remedy at law. The equitable relief is justified in federal courts where there is no adequate and complete legal remedy under its traditional equity power, provided there is a cause of action in equity. On the other hand, equitable remedies do not become available until legal remedies have been exhausted, and it is held with or without reference to the express provisions of the statute that equitable remedies are not available in any case where a plain, adequate, speedy, and complete remedy may be had at law. 21, enlargement of remedy at law. Established equity jurisdiction is not defeated because the scope of legal remedies has been extended so as to render them adequate. Equity jurisdiction, once established because of the original inadequacy or absence of remedy at law, is not defeated because the scope of legal remedies has been extended or is to render them adequate. As a general rule, However, a court of equity, as part of its inherent powers, has jurisdiction to grant any particular relief. Such jurisdiction is not lost or abridged because the courts of law of the same state subsequently may have acquired power to grant the same relief in the same kind of cases under the same facts or circumstances. Where a particular remedy is given by the law and that remedy is bounded and circumscribed by particular rules, it would be very improper for a court of equity to take it up where the law leaves it and to extend it further than the law allows. 22, next section, enlargement of remedy by statute. Pick up on these words where it says generally, where it says specially, where it talks about grant. It says there, the state subsequently may have acquired the power to grant. And my question would be, how did they subsequently get the power to grant? Because you gave it to them. You gave it to them. And pay attention to where it talks about circumstances all the time. These are key words for setting up your status of your estate, which is coming to the realization of the age of majority, which is your discretion, your ability to discern. It's the age of maturity, the age of majority. When you can read the code and decipher the code, and then you can unravel it in your mind, and then you can turn around and write the code, and you can give the order or grant the order. 22, next section, enlargement of remedy by statute. In general, the general rule is that where equity jurisdiction is established, a statute creating a remedy at law or removing the obstacles at law on the existence of which equity jurisdiction was founded does not oust equity of jurisdiction unless the statute affirmatively discloses the equity intent to make the legal remedy exclusive. According to one view, the fact that a statute may furnish a remedy at law does not necessarily take away equity jurisdiction over the subject. So the general rule is that where jurisdiction is in equity has become established, the statute creating a remedy at law or removing the obstacles at law on the existence of which the equity jurisdiction was originally founded does not oust equity of that jurisdiction unless the statute affirmatively discloses the legislative intent to make the legal remedy exclusive. Such intent may appear in new legislation either from the express language of the enactment or by clear implication deduced from such language. Although it has been held that in order to oust equity of jurisdiction, the statute must use restrictive or prohibitory words, and that in the absence of such language, the statute confers a concurrent and cumulative remedy. To oust equity of jurisdiction under these principles, the new remedy must be complete and adequate. There is authority, however, to the effect that the statutory enlargement of the legal remedies oust pro tanto the jurisdiction of equity, and that equity will not afford relief if complainant has a remedy by statutory proceeding in the original action. Where a statute creates a right and also provides a remedy, the remedy also provided is exclusive, and any other independent or cumulative remedy. So it is held that the courts will not entertain a bill in equity designed to call for a decision of a case for the determination of which a special statutory remedy has been provided. The statutory remedies have been required to be exhausted before resort to equitable jurisdiction. The fact that equity jurisdiction is conferred on courts of law will not operate to deprive chancery tribunals of their original and inherent powers. Next section, attachment and garnishment. Generally, a bill in equity will not lie where a plaintiff could attain his object by attachment, garnishment, or similar statutory remedy. On the other hand, an equity power to proceed by garnishment or sequestration may continue as a concurrent remedy after the enactment of a statute providing the garnishment at law, and this is true where the legal remedy is complicated with matters of purely equitable cognizance. Now, next section, tax matters. A statutory remedy precluding equity's court exercise of jurisdiction in a tax matter is inadequate only if it does not allow adjudication of the issue raised by petitioner, or allows irreparable harm to occur to the petitioner during his pursuit of statutory remedy. B, adequate statutory remedy. When jurisdiction has become concurrent through statutory enlargement of legal remedy and the remedy at law is complete and adequate, a court of equity will generally decline to give relief. The rule stated super in Section 18 that equity will not grant relief where, on the case stated, there is a plain and adequate remedy at law has been said to be particularly applicable where there is an adequate remedy provided by the legislature. And it has been held that where a statute provides an adequate remedy at law, equity will not entertain jurisdiction, and the statutory remedy must be exhausted before equity may be resorted to. So when jurisdiction has become concurrent through statutory enlargement of the legal remedy, a court of equity, although recognizing the existence of its jurisdiction, will generally decline to exercise it where the remedy at law is complete and adequate, and no special circumstances exist demanding the interference of equity. Stronger equitable features must appear, and the court is more reluctant to exercise its power where doubts arise as to the existence of jurisdiction. Where the existence of a concurrent jurisdiction is recognized, whether it be exercised or declined rests largely in the discretion of the court. Considerations as to the adequacy of the legal remedy controlling the exercise of such discretion. There are cases denying equity jurisdiction solely on the ground that the legal remedy created by the statute is inadequate. C, inadequate statutory remedy. Authorities differ as to whether equity will exercise jurisdiction where a remedy at law remains incomplete or otherwise inadequate after it has been enlarged or created by statute. The rule has been followed that where a mere remedy at law after statutory enlargement remains incomplete or otherwise inadequate as where it pursued is obstructed by such obstacles also would originally have grounded jurisdiction in equity, such jurisdiction is not ousted and the court will not hesitate to exercise it. Under other authority, whenever a legal right is wholly created by statute and the legal remedy for its violation is also given by same statute, a court of equity has no authority to interfere with its relief, even though the statutory remedy is difficult, uncertain, and incomplete. The mere fact that a constitutional question is raised as to the validity of the statute does not confer equity jurisdiction upon the court, but rather one must show the existence of a substantial question of constitutionality and the absence of an adequate statutorily prescribed remedy. The fact that a statute may be inadequate does not authorize a court to exercise any equitable jurisdiction. Next section, attachment and garnishment. It has been held that rights and remedies by attachment or garnishment cannot be added in equity, whereas elsewhere it has been held that if the remedy by attachment or garnishment is inadequate, resort may be had to equity where equitable grounds appear. Section 23, loss of remedy at law. In general, equity will not take jurisdiction merely because plaintiff has lost or has failed to rely on his remedy at law. When it has asserted a demand or a defense in an action at law has been defeated on the ground that such matter is of equitable cognizance and is not thereby barred from relief in equity. The circumstance that plaintiff has been deprived of his right of action will not alone confer jurisdiction on a court of equity to entertain suit. On the contrary, the doctrine is well settled that when a party has a complete and adequate remedy at law and fails from any cause to rely on it in that form, he will not be permitted to assert it in equity unless it was prevented by fraud, accident, or mistake. Unless he was prevented by fraud, accident, or mistake, or by such circumstances as he is unable to control, and such circumstances must be made to appear to the satisfaction of the court. One cannot entitle himself to invoke the aid of the court of equity by voluntarily casting away his remedy at law, otherwise adequate and complete. Next section, accident or fraud. The fact that one has lost his remedy at law through accident or fraud of his adversary is in itself a familiar ground for invoking the aid of equity. To obtain such a relief, plaintiff must show affirmatively that the loss of the legal remedy was occasioned by such matters of equitable excuse, unmixed with negligence on plaintiff's part. Next section, by defeat at law. Where one has asserted a demand or defense in an action at law, it has been defeated on the ground that such matter is of equitable cognizance. He is not thereby barred from relief in equity. If, however, the matter is one of concurrent jurisdiction and the party seeks his remedy at law and is there defeated on the merits, he cannot have relief in equity except on the ground of fraud, accident, or mistake. B, by neglect and laches. Where a legal remedy has been lost through neglect or by failure to seek it at a proper time, equity will not interpose to grant relief. In the absence of a showing of sufficient cause for such neglect or failure, it is well settled that where an adequate remedy at law has been available but has been lost either through neglect or positive negligence or merely by failure to seek it at the proper time, equity will not interpose to grant relief, and in the absence of a showing of sufficient cause for such neglect or failure. This rule finds frequent application in cases where a defendant in an action at law fails to interpose a defense which was there available and then applies to a court of equity for relief against the judgment. If, however, the defense is of a character that it might be made either in law or equity, the Court of Chancery will afford relief, although the party has neglected to make his defense at law. The general rule is applied where defendant at law might obtain redress by appeal or certiorari, and in cases where the remedy was available by motion in the law proceeding, where, however, the bill is founded on matters of original equity jurisdiction and not merely on the loss of a remedy at law, it is held sometimes that relief will be given, although the plaintiff might have availed himself of the equitable feature in the law action. Where the legal defense would be futile, as where it depends on evidence and admissible by law, but potent in equity, plaintiff may have relief without showing any other excuse for not defending at law. Next section, C, by statutes of limitations. Under most authorities, the mere fact that the statute of limitations at law is no ground in itself for applying to equity for relief unless plaintiff was prevented from suing by defendant's actions. Well, it's been held that a court of equity will entertain a bill where one would unnecessarily, except for the fact that the early termination of the statutory period would defeat another remedy. Generally, the fact that a limitation statute could bar a remedy at law is no ground in itself for applying to equity for relief unless plaintiff was prevented from suing by the act of defendant himself. The mere fact that a remedy which is purely legal has become barred at law through the fraud of a defendant cannot give equity jurisdiction to enforce it. 24, adequacy of remedy at law. Adequacy of remedy at law. In general, the existence of a remedy at law does not deprive equity of jurisdiction unless such remedy is clear, adequate, and complete. To meet this requirement, the remedy at law is required to be practical and efficient to the ends of justice and its prompt administration as the remedy in equity. The existence of a remedy at law does not deprive equity of jurisdiction unless such remedy is clear, full, adequate, and complete. By this is meant that it must be clear, complete, and as practical and efficient to the ends of justice and its prompt administration as the remedy in equity. So it has been held that equity will assume jurisdiction where one's remedy at law is not as complete as, or would be more difficult than, the remedy in equity, or is less effective, or is less complete and satisfactory. An adequate remedy at law has been said to be one which is specific and adapted to securing the relief sought conveniently, effectively, and completely. An adequate remedy at law means a present remedy and one vested in the complainant, to which he may at all times resort at his own opinion fully and freely without let or hindrance. A remedy at law cannot be adequate or complete if its adequacy is and completeness depend on the will of the opposing party, or if the party interested must appeal to the discretion of some other person or body, as were the continuance of proceeding and the plaintiff's right to participate therein, or matters of grace. The remedy must exist against the same person against whom the relief in equity is sought. It is not necessary, however, where the relief afforded shall be the same kind of relief that the court of equity could give, and although there is a contrary authority, it has been held unnecessary to be attainable within the jurisdiction where defendant raises or where suit is brought against him. The remedy at law is not adequate if the situation requires, and the law permits preventative relief as preventing the or continuance of wrongful acts, and the legal remedy is never adequate if the injured party will sustain irreparable damages by being forced to resort thereto, and even though he may ultimately prevail. A court of equity will determine for itself the adequacy of legal remedy, and where it is a doubt as to the adequacy, such doubt should be resolved in favor of the equitable jurisdiction. In determining whether the equitable relief is appropriate, it is the remedy itself. It is not possible lack of success, and that is the determining factor. The application of the rule that equity jurisdiction cannot be invoked where there is an adequate remedy at law depends on the circumstances of each case. Whether a litigant seeking equitable relief has an adequate remedy at law is a question of law, although there is authority to the effect that it is a question of fact. Next section, clearness, certainty. Where the adequacy of a legal remedy is doubtful and equity can give relief, plaintiff ought not to be compelled to speculate on the chance of his obtaining relief at law. The legal remedy must therefore be clear, plain, and certain. Next section, completeness. A remedy at law cannot be considered adequate so as to prevent equitable relief unless it covers the entire case made by the bill in equity. To oust equitable jurisdiction, the remedy at law has been required to be so complete that it attains the full end and justice of the case, reaching the whole mischief and securing the whole right of the party. So where the legal remedy is available but would afford only a partial protection of the plaintiff's entire right or would not entirely adjust the rights of the parties, such a remedy is incomplete and inadequate, and for that reason equity will interpose. Next section, convenience, difficulty. Under a number of authorities, the greater convenience of an equitable remedy is no ground in itself for resorting to equity, but other authorities hold that a bill in equity may be sustained solely on the ground that it is the most convenient remedy, while equity jurisdiction has been sustained on the ground that the remedy at law would be cumbersome or inconvenient and therefore inadequate. The element of inconvenience is almost invariably combined with other circumstances of inadequacy and is too indefinite safely to afford an independent ground. Where the remedy at law is difficult and doubtful, equity will entertain jurisdiction. Next section, practicality. Notwithstanding repeated statements in the cases that oust equity of jurisdiction and remedy at law must be as practical as in equity, some decisions indicate that the rule of practicality does not relate does not relate to apply to obtain fruits of the remedy, but to its fitness and the nature end in view. If a remedy is adequate in theory and in law, it is not deemed inadequate merely because, owing to external causes not contemplated by the law, it cannot be enforced. So it has been said that insolvency alone is not a ground for equitable interference, but there is authority that recovery on judgment is as essential to make the remedy at law adequate as is the right to obtain the judgment. Equity jurisdiction will not attach solely because of the possibility of a larger recovery than at law. Promptness, next section. The greater promptness of the remedy in equity is often given as a reason for substantiating its jurisdiction. It does not mean promptness in administration, depending on the state of the calendar, nor does it mean that the progress of a suit in equity is inherently more speedy, for on the contrary, which progress has been generally notoriously slow. It relates rather to directness of remedy and the avoidance of circuitry of action and multiplicity of suits. Next section, speed. To have the effect of ousting the jurisdiction of a court of equity, the remedy at law must be speedy. Next section, availability. It has been held that equity will afford relief where legal remedy would not be immediately available. Next section, adequacy of jury. The adequacy of a legal remedy necessarily involves the adequacy of a jury and its competency to find the facts. B, federal jurisdiction. The usual test for adequacy or inadequacy of a legal remedy prerequisite to resort to a federal court of equity is legal remedy which federal rather than state courts afford. The remedy at law which prevents the exercise of jurisdiction of a federal equity court has been held to be one which was in existence when the Judiciary Act of 1789 was passed, or which has since been created by the Act of Congress. While it has been held that an adequate remedy at law provided by state statutes is sufficient to preclude federal jurisdiction in equity, the usual test of adequacy or inadequacy of the legal remedy prerequisite to resort to a federal court of equity is the legal remedy which federal rather than state courts afford. The jurisdiction of federal courts of equity as determined by the test is neither enlarged nor diminished by the names given to the remedies or the distinction made between them by state practice. Thus, an adequate remedy at law created by state statutes and available in state courts cannot oust the federal jurisdiction of federal courts of jurisdiction and equity. While a right is dependent on a state statute, the jurisdiction of the federal court has been law and equity must be determined by the essential character of the case. Section 25, legal remedies deemed adequate. A remedy at law means a remedy in a court of law, and no other remedy ousts the jurisdiction of equity. A remedy at law means a remedy in a court of law, and no other remedy ousts the jurisdiction of equity. However, there is authority that equity will not interfere where an adequate remedy is afforded by some special mode provided by statute. While the existence of an administrative remedy does not bar the aid of equity, the equitable intervention is appropriate where the administrative process is inadequate to resolve the dispute. It cannot be said that there is an inadequate remedy at law until all administrative remedies have been exhausted. This is a rule of special force. When resort is had to the federal courts for relief against the actions of state officers, the extent to which the federal court may relax the rule where the order of the administrative body is assailed and its entirety rests on the sound discretion which guides the exercise of equity jurisdiction. Equity will not take jurisdiction if there is available a single remedy at law sufficient for plaintiff's protection or several remedies which are together sufficient. Next section, 26, money demands. Equity will not ordinarily take jurisdiction where money judgment is the ultimate or only relief sought. Where compensation and money will afford complete and efficient relief, and where money judgment is the ultimate or the only relief sought, the remedy at law is usually adequate for the purpose, and a party will be regulated thereto of a legal remedy is unimpeded and there is no other equitable circumstances to support the jurisdiction. Equity will generally not interfere where it appears that there is an adequate remedy at law for damages. Thus, sumpsit or analogous actions must be resorted to where available unless some other basis or ground of equity jurisdiction is present. This is true even where plaintiff claims a specific fund or part of a specific fund which defendant has received or ought to have received, provided no further equity exists. The refusal of equity to take jurisdiction is not, however, due to any inability to render a decree for damages alone, and there are situations and circumstances in which a court of equity may make a decree for the payment of money. Such relief may be given in support of established equities, even though a sumpsit would lie and afford a measure of protection, as where a fund is impressed with a trust, or where it is occasion for an adjustment or distribution among several parties, or whether it is sought to transfer a lien on property to the proceeds of its sale, or where plaintiff is entitled to discovery and an account. Where the remedy by action for damages is inadequate or is insufficient to do complete justice between the parties, equity will take jurisdiction and grant proper relief. Even though the plaintiff's right at law is fully recognized and a money judgment would afford adequate relief, there are rules of procedure present obstacles to the attainment of such relief at law. Equity may be invoked to remove such obstacles. It's also been held that the fact that a plaintiff may have a remedy at law by an action for damages does not prevent equity from assuming jurisdiction if the equitable remedy is better adapted to render more perfect and complete justice than the remedy at law. Nevertheless, it has been held that equity cannot enforce an action for damages merely because it has jurisdiction for an accounting, and by this means enforce demands which a court of law could not enforce. Where a sumpsit would not lie, equity will aid in recovery of money equitable due to plaintiff. Thus, a bill in equity lies to follow the recovery trust funds disposed of by fiduciary. Where a party seeks a particular fund, such as the proceeds of an insurance policy, rather than a mere money judgment, he need not show that there is no adequate remedy at law in order to submit a cause to equity jurisdiction. The adequacy of a legal remedy for damages does not depend on the collectability of the claim. Next section, covenants. Pursuant to the general rule, equity refuses to interfere to protect a purchaser or leasee of land from the consequences of failure of title or encumbrances. Where he has a remedy available at law on the covenants contained in his deed, unless there is some special equity to support the jurisdiction, and in which case equity will afford relief, as where discovery is required or the legal remedy is otherwise impeded. The same rule applies to other covenants. Next section, bonds. So too, if a party is adequately protected by a contractual or statutory bond, he may require to resort to an action on the bond. However, there is also authority to the contrary. Next section, liquidated damages. Liquidated damages cannot be recovered in equity unless the remedy at law is inadequate. And I think I'm going to stop there. We'll pick up next time on Section 27, torts generally. That may be a good place to break it there. All right, so we'll go to Q&A mode.
Q&A session started.
All right, you have to press *6 to get in the line for the queue, and then followed by *1 to ask a question. Press *6, *1 to get in line in the queue for asking questions. Okay, 201, you're on mute.
Hey, CW, this is Bill from New Jersey. How you doing?
Hi, Bill. Okay. Give me a little voice rest here, I'll be better.
I'm sorry?
Give me a little voice rest here, and I'll be better.
Okay. Well,
go ahead.
I guess you have tomorrow and I guess part of Monday. It's interesting that you're reading from the CSJ, because I was doing that today, and also reads further on that the real, I guess, bridge into equity are the maxims, in addition to fraud and stuff like that. So isn't that something that we should be aware of as well?
Yes, the statutes of frauds, but then keep in mind, that this is all statutory, and who knows what they've changed so far.
Well, what I'm saying is that the heart of equity is
1933.
Right, but the heart of equity are the maxims.
Yes, right, yeah. I
So then, right, so if that's the case, even though we have the statutory stuff which comes before the maxims, really it's the maxims that give us, I'm asking, will that give us a greater standing or greater power?
Yes, in equity, right. But anytime we start arguing the merits at the at-law side, then we traverse into the case, and I would say we're kind of barred to get into equity at that time, unless it's provable that you can't give an adequate remedy at law. But then that is always true because there is no money. There is no lawful money.
Exactly. But during the readings tonight, there were like some readings that you made that indicated, well, say fraud. If there's fraud, isn't that a direct avenue to equity?
Yes, fraud, mistake, and I forget what the other one was. There were three of them that were listed.
And also, and there's some places they talk about, if you have a fraud, they define fraud as a breach of trust.
Yeah.
So when we prove a breach of trust, that's fraud, which automatically traverses into equity.
Mm-hmm.
And then we add, the maxims, unclean hands. We add the unfair competition, unjust enrichment, and things of that nature. And we're really building a case for equity. And then what you said too is that we can take the power away from the legislature with respect to a particular statutory rule, and that just makes us a lot stronger.
Yeah, in fact, I was hoping you picked up on that one section I was reading about where the equity doesn't take the place of the legislature, although it will force the legislators and the officers to do the duty that the law requires. So I was hoping you picked up on that, because it was like referring back to what I thought was the past couple of weeks ago about your education thing.
Right. Could you expand on that a little bit? Because legislature they make these rules. They are the guardians, but if we claim back or become of age, then we can, what power do we have to correct that?
Well, we have both the equitable enforcement for them to do the duty as well as to not breach the public trust of the laws, which I say, is where our power really lies, is because if we know that somebody's going to breach the trust, then we can prevent them from breaching the trust by coming into equity and forcing them to do the duty, not breach the public law, the public trust.
Public trust is
what is the definition of law? Because most people think today that whatever the law states is justice. And that's not so. Just because the law is the law doesn't mean that the law is lawful. The law could be unjust. And today the laws are used to enforce the injustice of the laws themselves. The plundering of we the people.
Exactly.
The laws today are used for that purpose.
And then also you could use another avenue, your civil rights, plundering. They can't plunder you, the raping, denying you the right to make a living. Those are things that can be put into the claim for equity.
Yes, today the law, which is the public trust, the body of law is the public trust. That's the law, the statutes and codes. The law today has come to be an instrument of injustice. The perversion of the law is a principle of the whole system itself.
Okay, so now how can we, based on what we know now about changing the titles within the public trust, what move can we make to say there's a whole body of, well, there's 60 million laws, but what do we do?
Yeah, but now that's the jurisdiction of the one venue, but now trust operates in a different venue, different jurisdiction.
Mm-hmm. So what happens in the public trust, the statutory public trust venue? How do we navigate in that?
Well, there's where we can use the equitable power of the trust in not breaching the trust, or after breach of trust, forcing them to do the duty or the obligation of the trust.
Mm-hmm. At the same time that we have to claim the trust first.
Yes, he who claims trust has to prove trust, or else there is no trust.
And then
that's surprising. Everybody talks about the city key trust, the foreign situs trust, the birth certificate trust, the Social Security account being a trust. They claim that they're trustees on the trust, but yet they do not claim and prove a trust. And if you don't prove the trust, then there is no trust. Now you wonder why they don't honor your instruments drawn against that trust. Or you come into court and they don't honor your, when you say that you're the beneficiary, or you're the trustee, or you're the grantor. Unless you prove trust first, you don't have that authority, you don't have that status.
Right.
And they don't have the right to accept anything that you write against some fictitious trust that you never expressed first into existence, because it does not exist in their law form, in their venue, their jurisdiction, until you manifest it there.
Yeah, that's another thing. It seems that equity is the content, substance, and the other side is more the form.
Yes, the at-law side gets its substance from equity, because the equitable maxims are really based on your 10 commandments.
Right.
But the purpose of the law today has been perverted. The purpose was originally meant to be to prevent injustice from reigning.
Right. Well, it's because too few people speak up. For example, in my case with electricity, there are thousands of people.
They don't know what the law is. They have no idea what the law is, and
right.
that's intentional. That's intentional.
Well, what happens is there are many people who know that the utility has to give notice. The utility doesn't give notice. They turn people off, and people just, you know, they do other things. They lay down and die. They seek out other remedies. But, you know, very few people stand up and say, look, you know, you violated your own laws. And that, to me, seems to be a very strong case for going into equity, because the utility company does what it wants. It completely disregards all your rights. You know, it does what it wants, not what's fair.
The consensus is you can't fight City Hall. But
exactly.
In reality, yes, you can. In fact, you're the only one who can.
Right, and so that's why the lawlessness is taking place, because very few people know how and are willing to stand up to fight City Hall, as it were.
Yes, they don't have the tools available to do it. They don't realize that they can, and therefore they can't.
Okay.
But that's planned.
I'm sorry?
That's planned.
Oh, yes. So now, when we have, once again, going back to the public trust, the opposing statutes are in public trust, is that right?
Say that again. I didn't quite catch that.
All the codes and statutes, are they in public trust?
Yes. All the statutes and codes are public trust.
Okay, so now how do we use the moving titles, or do we use the moving title concept or any particular code or statute with respect to our particular issue?
Yeah, yes. If I could find where I was reading there quick. Because it was talking about no, I can't find it. Oh, here it is. It was under Section 16, the judicial character of relief, where powers which were exercised by a court of equity are solely of a judicial character. Therefore, the court of equity cannot perform an act which the law entrusts to the discretion and control of municipal or other public officers, or control them in the exercise of such powers, except to prevent an abuse of discretion and to require that their powers be exercised according to law and in a manner not to injure unjustly rights protected in equity. That's what they're trying to do. You know, this is the power for you to correct something before it happens, except to prevent an abuse of discretion and to require that the powers be exercised according to law. There you've got the power to do that. But they leave off the last part, which is, and in a manner not to injure unjustly rights protected in equity. That's what the law forgets today.
Right.
That part's left off. And we have no inkling of what is injurious to us, because we don't understand what the law really is in equity, what the maxims of what the at-law side should be based upon, which is the maxims in equity. And those maxims in equity should be based on the Ten Commandments.
So then, once again, when we bring forward the maxims, fraud, and we are, even our civil rights in terms of the right to make a living, to live, not to be wiped out through genocide, those are the type of things that will give us a pretty strong position, remedies at inequity as opposed to remedy at law, because usually at law they don't deal with that stuff.
Yeah. Today, you know, why are we going over equity? Well, really, we need to get a remedy, and if we're going to get a remedy, the remedy's not at the at-law side. The remedy is in equity, because there is no adequate remedy today at law. And that's why we're reading equity and studying equity a little bit here, so we know how to take a trust into equity and get a remedy.
You know,
that's the whole reason why we're studying this equity.
It just occurred to me, they said you have to exhaust your remedy at law, but if only 16% of the defendants prevail, then isn't that proof that there's no remedy? Hello? Hello?
Yes, today there's some remedies out there, some methods that achieve a remedy of a higher degree now, and those are just strictly by litigation methods. But that's not the point. It's not the point that you get a remedy at law today. It's the fact that there is no lawful money and you can't get a remedy today.
You can't pay.
Even if you win, you can't get a lawful remedy today.
True that.
So what did you accomplish if you stop your mortgage foreclosure, if you still don't own your property and you still only have possessory title because the trust split the titles? And what do you have of value in a home that you stopped from foreclosure that there is no money of any value to value it against, and your house is valueless. So today, even if you win at law, you still haven't gotten an adequate remedy at law, because without lawful money, it's impossible. It is zero. So why would you even want to pursue really an adequate remedy at law when the only way you can get one is really in equity, even if you could win at law? You see my point?
Oh, yeah, but let me ask this question. It's like, what do you mean? What do they mean by say at law? Do they mean the post 1933, or do they mean at law, the non-legal stuff? What do they mean by that?
Well, I would say that it would be post 1930 statutes and codes.
So they're using a colorable term of art to mean legal as opposed to lawful.
Yes, right. Yes.
So then lawful would be closer to equity.
Yes, you're right.
Would it benefit us to make distinction in any of our actions?
Would it benefit to do what with our actions?
Yeah, to make a distinction between, the lawful legal paradigm.
Yeah, well, I think the at-law side is the wide gate and the equity side is the narrow gate, and few there be to find it. And we're always like a dog to its vomit, going back to get a remedy at the at-law side when there is no adequate remedy at law.
Okay, so is it like at-law and in-law? Is in-law the equity and at-law is the statutory?
In-law would probably be equity, yes.
Okay.
At-law would be statutes and codes post-1933.
Well, okay, it's a very good dialoguing with you, and I'm reading some of the same material. I'm glad you brought it up, and keep up with your work.
Reading CJS also? You have
Yes,
a copy of it?
Yeah, no, well, I haven't got one yet. I was at the library today, at the Rutgers Law School Library, and I was reading that today.
Oh, good, very good. Glad to hear it.
Yeah, so I'm going to add, and then I have the trust book, I'll do the Guardian, and then also at the special deposits for the bank today. So, it's just very informative, and and the equity, there's so much stuff in there. It goes one way or the other way, but I was reading about the maxims. The maxims are very interesting as well.
Right.
And then there's the issue about latches. I would think that we would want to, look at latches as to overcome the latches, because that's a defense to a trust. We need to look at latches as well. Yeah.
And then you have to take this with a grain of salt and say, hey, this might be so much, BS in there because its influence is post-1933, and you have to take it with a grain of salt also.
True that, but I was meant what you were saying. We need to, we have to use the Sun Tzu principle.
Right.
And as you said also, we want to know more about this than the lawyer or the attorney.
I'm sure by the time we get done with this, we will know more about it than the attorney.
So that's why I bring it up. It's just so that we have an idea what's it all about. Because in planning a claim, I look at it in terms we have to know the possible defenses for what I say against you. So that's what I would say. We have latches.
Yes, right. Okay, well, let's move on. Let's give somebody else a chance to ask something. If you got something else, come on back in.
No, I'm good, man. Thanks a lot.
All right, thank you.
Peace.
Okay, you have to press *6 and *1 to get in the queue, ask a question. I guess there's nobody up on the board yet. Tammy, you're unmuted. Tammy, you're unmuted.
Oh, hey, hi, Christian.
Hey, Tammy.
I got on late. I got on at 9 o'clock thinking it was 9, but it's Saturday and it's an hour earlier. And I take it you were reading from Corpus Juris, and I chimed in about the time where you said you were going to stop at section 27 on torts. So were you reading something prior to torts, or was it just all about torts? Or?
Yeah, I did the section under remedy at law.
Okay. I'll make a note of that. Remedy at law.
I guess there was a couple sections before that where we actually picked up, but
okay.
The title of the show tonight was Remedy at Law.
Okay. Yeah, bummer. I didn't realize the time.
Yeah, that was section...
yeah.
Where's that? Section 17, where it starts.
Okay. Alrighty.
You missed it.
Yeah, I missed it. That's okay. Maybe I'll get a recording. I did find in Federal Rules of Evidence, this is in regards to getting things recorded. People were trying to get a cheaper way of getting things into the public because public recordings of these UCC ones are not cheap. They're like, well, here they're like $56 a pop. And so under Rule 902, Federal Rules of Evidence, under self-authentication of documents, the way I read it, one can, for example, post it on a website and have a notary public attest thereto, and it is self-authentication per Federal Rules of Evidence 902. So if anybody wants to glean in on that as well, that's how I read it. Documents, let's see. Documents, acknowledged documents. It says documents accompanied by a certificate of acknowledgement executed in a manner provided by law by a notary public or other officer authorized by law to take acknowledgments. And the only other thing it says is that the adverse party must have sufficient information of it. So the person might want to even send notice to the other party that things are recorded in the public, that type of thing.
Yeah, it's always important to give the other party due process, which is give them notice.
Right. So that fixes that. And then this friend of mine that's, I don't know that she has it up yet, but she's got a website that she's going to have up and running soon called www.publicnotices.info, and she'd be willing to post anybody's recordings there. And how, I don't know, but she seems to know. So I don't know whether it's via email, and I'll find more out from her.
Yeah, well, I have a comment on that.
Go ahead.
Unless she derives her authority from a public source, then she does not have public recognition.
Okay. Even if it's on the internet, on the web?
No, it's got to comport to their public source somehow.
Okay. So we're back to square one. Dang it.
Yeah. Well, I'd make sure I check that out to see whether or not that's going to fit in one of those pigeonholes that they got that they will recognize.
Right.
Otherwise, you'll be thinking you've got some kind of record and it can't be seen.
And they won't recognize it, yeah.
Right.
Okay.
So I wouldn't make that mistake.
Okay. All right. More stepping stones to crumble. Can I put this to bed once and for all in regards to the UCC1 finance statement now, where you're claiming? Now, my opinion is that under box 1, it's either the organization name or the individual name. If you're going to put down, say, trustee, or trustor is, okay, trustee would be the debtor, you'd want to put down, and then the secured party area in trust terms, trustor, and vice versa. You'd want to be following suit by grantor, grantee, not one block saying the debtor's the trustee, and then in the secured party block, you wouldn't want to put down that you're the grantor, or would you?
Well, if, I forget which one it is. Block 5, which is the nomenclature change on a form when you put a little check block in and say Baylor, Bailey, Baylor.
Yeah, that's cited on the form. That's
Yeah, it's
right,
usually
that's
the EEs are the first ones, which is block 1, the debtors.
right.
And the ORs are the secured parties.
Right. So what I guess what my question is, we'd want to stay on the same tune. In other words, if we're listing the debtor as trustee, wouldn't we want to list the secured party as trustor?
Yes,
Or,
right. But trustor is the same as grantor or
Right.
lor.
Right. So you wouldn't want to go trustee and then in secured party grantor. You'd want to keep it.
Well, you can put any kind of nomenclature on there you want, just whatever you put in that, say, optional block 8 that comports to block 5, which changes all the nomenclature on the form.
Okay, okay.
You can set the rules yourself or put it in collateral block 4 also.
Right, true. Okay. All right.
Why nomenclature change is grantee / trustor. That's what it is.
That's what it is, yeah. Gotcha.
Yeah.
All right. I won't split hairs with that issue anymore then. As long as you know, set it yourself on what it is, and that either in the collateral box or in box 5.
Yeah.
Yeah.
And you just have to pay particular attention to what you're doing and make sure that you got the EEs in the right position with the ORs.
Right. Precisely.
You wouldn't want to put grantor / grantee. It's the other way around.
Mhm. Definitely. Okay, that clears that out. And then also, if there's anybody that is a, ambassador that's in Minnesota, get a hold of me with their Skype or nearby state or whatever, so I can start working with some people here. It'd be great.
Have you got a Skype name to contact you?
Yeah, I have to go. I just reinstalled Skype. I'd have to go back and look at what it is. I'll chime back in when I figure out what my handle is.
Okay.
All right. I'll sign up for now. All right. Thanks, Christian.
All right. Thanks, Tammy. Okay, press *6, *1 to get in the queue line. Press *6 to get in the line, *1 after that. Anybody have a question? Press *6. Next caller, you're unmuted. 415, you're unmuted.
Sorry about that. I had the mute button on. Christian, there is the National Republic Registry that has received papers that allows a person to get certified for filings. There's like 2 or 3 other different registries that last week I had posted on our group, the NTT group. I posted the website of the ones that have recently received a certification from the recorder's offices for filings separate from the recorder's office itself. So in other words, there's been some honorable relations established between what we have set up as registries. And that was just posted this last week. I don't know if anybody can go back and retrieve that out of the Skypes, but you've got the National Republic Registry, which is being recognized in addition to the one I posted.
Okay, great. That's good. As long as they can make a connection to the public, then that authority passes through. Then that, if you record something in there, that'd be good then.
The other thing that they actually do is that once you do post your documents, they can actually give you a certification that it's been publicly posted, like it would be out of a newspaper, and it would really cut your cost when you get a certification back that you've posted that, like in a newspaper ad. Those are legal documents that can be taken to your recorder's office. So if you're doing land patents or if you're doing any kind of declaration, these things still are valid, as just like posting them in a newspaper.
Okay, great. That's posted up on their site?
Yes. In fact, on TalkShoe when I was with AIB Radio, I had the founder of National Republic Registry come on the call, and she walked everybody through everything you can use and what you can do. And it's pretty simple. You can basically follow their instructions, and they've got an 866 number during the week times. You can ask them any question of how you properly file stuff. So there's no shortage of being able to have access to the National Republic Registry.
Okay, great.
But there's about
nationalpublicregistry.com or something?
Yes. And as I said earlier, there was a gentleman, which was an attorney out of Sacramento, California, that got fed up with the refusal to have documents filed. He himself set up a registry right out of Sacramento, of which I'll have to go back and retrieve the information on that. But right now we've got about 3 or 4 real bona fide registries that we can utilize for our benefit for certifications, notices, and declarations and whatnot. So, anyway.
Great, so we got 2 bona fide sources on top of that then. Yeah, great.
Right, so that's pretty much it for right now.
Okay, thanks, Chris.
Yeah, bye.
Press star 6 to get in line for the queue and star 1. (201), you're unmuted.
Yes, this is Bill again.
Hey, Bill.
With respect to the information that Chris just gave, how does it fit into our UCC 133 format?
You could substitute a UCC 1 in place, or the county in place for it, you know. All we're doing is creating 2 witnesses for 2 notices.
Okay, we still have to do the 2 separate 3s?
Yeah, I still like the UCC for the main one, because that UCC 3, that's actually a transfer, and transfer is one of the methods of formation of a trust, and that's kind of like a duality document, that something that's colorable that they could say, well, on their public side, they can look at that and say that was a transfer in itself. Although I look at the transfer actually being when you gave trust res to the trustee, that being the transfer, and then that UCC3 being the notice of that transfer. But I still like the UCC ones. But if you had trouble in the county, yeah, you could probably substitute that national registry for, or another one like it.
Plus, isn't that the 3 also goes with the state of your state, Secretary of State of your state?
Yeah. But, you know, we're doing these onlines in different states. It's just a fact, you know, we could bring them in local, state-wise if we wanted to.
But what I mean is it's a higher authority. It's a higher authority, or whatever state you're filing in. It's the Secretary of that state, which is directly under the Secretary of State of the United States of America, which is a stronger relationship, I would imagine.
Possibly, but I could come in with any kind of foreign jurisdiction document and through the Foreign Judgments Act, say, or get an apostilled. I could still bring it into any state if I had to.
Yes. That's good.
If I had a local action or something. So I don't need to worry about, well, I filed in Washington State for my UCCs, or Kentucky, or wherever, or California, or whatnot, you know. So and I lived in Montana, say, or Texas, you know. I could still bring those recordings into, say, Texas, and so anyway.
Okay, thank you.
Okay, anybody have a question? Press star 6, get in line, and star 1 after that. Next caller, anybody? Nobody in line? You're unmuted there.
Hey, CW, Michael.
Hey, how's it?
It's going fine. you know, when you were talking to Bill in regards to, you know, equity, going into equity, now are you specifically talking about a DIB hearing or, you know, as we were before, or an in-camera when we express the main trust?
I would say they're probably the same thing. DIB hearing or equity. Or
so when we go to express it, excuse me, this would be with Rios, meaning the main trust, and go for a DIB hearing, or would we do that on the IMS side, which would be the commissioner of the IRS?
Both. Either one. Same thing.
Okay. Okay.
All
right.
It's all one equitable jurisdiction on the private sides of all entities, and that's where we want to go through, just like the private side of the court.
Okay. Now you mentioned the Ten Commandments as being the maximum of law, which is in Scripture, but that would be in the trust res, correct? Along with the, you know, Declaration of Independence. Is that correct?
Yeah, if we're going to claim our Bible as being one of the main master trusts, along with the Declaration of Independence.
So everything that basically what you're reading out now is the same thing that we were speaking of before. It's just more evidence that this is the way that we need to go. Is that correct?
Yeah, really. I don't see anything that's really changed except maybe our a little more crystal clear clarity as to what we've already got, because I'm looking like a beach ball or a rubber ball that I'm only seeing one half, and I don't see the section that's the chunk that's missing out of the back side. But then I turn the ball a little bit and I see, oh, there's something missing there, and then I see that, well, agency plugs in there, and it touches the core, which is the trust.
It's just that it's the key words that you said earlier that we need to start using or bring into expressing it when we notify Rios or the IMF, the IRS. It's just these key words that we have to use, which is basically what you've been going over for the last 3 weeks.
Because I see a sequence of words that keep popping up in corpus, and I think these are the switches that we're going to have to use and know which side they're on, whether they're on the public side, those switches for that recognition, and on the private side, we've got those other words that we use for our recognition.
Well, I went through what you said about a week ago in regards to looking at Black's Law, and it's all through Black's Law that the trust and the CJ, or what you're reading out of now, it refers to that in these key words. So I agree with you, and it's basically a second witness or even a third witness in that regard of what we've been going or learning for the last 2 weeks, 3 weeks.
Right.
Okay. I'll let the next person talk.
Thanks, Michael.
Thank you.
201, you're unmuted.
Hello?
201, you're unmuted.
Yeah, Bill again.
Hey, Bill.
So this is a question, I guess it's kind of basic, but I just want to clear it up. How many different positions in the trust can we hold at one time?
I think just 2.
Okay, because I've been dialoguing with some people.
Fully, let's put it that way. You might be able to have a beneficial interest, say, and also be trustee, and you were grantor. But there would have to be some other beneficiary other than you. You have to be a co-beneficiary, say.
Okay, so then that gives us a great latitude then.
Yes, it does. Yeah, because Gilbert's was talking about, trustee could have co-beneficiary rights, but then if he was grantor and trustor himself, or trustee, grantor and trustee within himself, he would be trustee administering the trust for the benefit of somebody else. Now, he could have also saved himself some co-beneficiary rights as beneficiary, but there would have to be another party who would have to be the main beneficiary.
Okay, but with that, in that regard, though, it's not necessary to know the names of the beneficiaries, is it? He can name the general public.
Not well. Sometime in the life of the trust, there would have to be some way to identify positively who the beneficiary is at the time.
So that would mean that a class action suit, for example, that would be an example of that situation.
Yeah, you could have a class of people that could be specifically identified as a class. That would be a group of beneficiaries, right?
So in that case, I have to be grantor, trustee, and co-beneficiary.
Uh-huh.
And I would have the full rights of the other beneficiaries to compel the trustees or co-trustees to conform to the terms of the trust.
Yeah, I forget exactly what section it was in Gilbert's, but we went over that section there.
All right, so that is the one situation where I can hold all three hats.
Yeah, so that opens up a lot of possibilities, multiple positions and powers and combinations and things.
Okay, other than that situation, I can only hold two positions.
Yes, I think it's just two. You either have to be grantor, trustee, or grantor and say beneficiary.
Because
and although I know on the public side they don't like to see you being grantor and beneficiary, but although it can be grantor and beneficiary on the private side.
Okay, so now in the Lewin book, it said that, well, I think it was Lewin or the Bogart book, it said that, if you had all three together, there would be no trust because it's like
Correct.
doing it. Yeah.
Right.
However,
yes.
if you have the additional beneficiary, then that's an exception.
Yeah. Right.
Okay, now is this on the private side or the public side?
That was on the public side because that was out of Gilbert's. That was statutory.
Right. So we could go in on the public side using that particular strategy.
Right. Mm-hmm.
Interesting. Okay. Well, thanks again.
You might want to review that section in Gilbert when we talked about that.
Yes, you're right. That's it. Thank you.
Okay. Next caller. Chris, you're up. Hi.
Yeah. The other registry that I did post over at NTT is called the nationalpublicrecords.com, and they had a major win. Apparently, I haven't got into those documents except for just a couple of minutes, but they had a major win that allowed them to interface with the documents that they post as being legally noticed. So I would say if everybody went to the nationalpublicrecords.com, that would be a second source to record documents.
Okay.
So, and then I know there's at least two others, and as I find them, I'll just call back in.
Okay.
All right. Thanks.
Thank you. Anybody else wants to ask a question? Press *6 and *1 to get in the queue. We got an empty board again. Anybody have a question? Press *6, *1. 979, you're unmuted. You're unmuted. Texas?
Hello. I have a question for you. And you probably
Go ahead.
You probably beat this to death already. But I just got a deed of trust in Texas. And it's been bugging me because it says deed of trust and then it's got security instrument. And then it has me as the grantor. And then the trustee is someone that worked for the lender. And then of course the lender is the beneficiary. I was reading, I was on some of the other calls, I think it was you, I'm not real sure, gave mention that the person who actually sells the home is usually listed as the grantor, and so I'm a little confused as to how the process works with me being listed as the grantor as far as getting the separating the taking the two the title that's been split and putting it back together, because they have this listed as a security instrument, and then they have the note referenced in there also in this document.
Okay, do you have a security agreement with that?
I've got a deed of trust, and then I've got this deed of trust is this. It says deed of trust, and it's got parentheses, security agreement, close parentheses.
That's what I thought. Yeah, that's what I thought. Yeah.
Does that answer your
So
question?
they got you listed on the security agreement as the grantor.
And then after my name, they have parentheses, borrower, close parentheses.
Who's the grantee?
There is none. They have a trustee.
A trustee. Okay. Who's the trustee?
It's Francis something Jr. Works for the State Director of Rural Development, State of Texas, U.S. Department of Agriculture.
Oh.
And the trust and the...
Well, you've granted it to them.
Okay.
Does it say upon default or something that takes place?
No. Mm-mm. Doesn't say upon default.
Have you read through the whole thing already?
Yeah, I've read through it once or twice, and I don't remember anything about it being...
precedence in there that establishes upon some kind of certain thing happening, then the transfer takes place or something.
Okay.
I know in a county here in Florida, instead it was the grantor was the previous seller, and the grantee, which was the person who purchased the house. But that's in the county.
It says right here, it goes through who the grantor, trustee, and beneficiary is, and then it says borrower is indebted to lender under the following promissory notes, and then it lists the promissory note, and it says this security instrument secures to lender repayment of debt. What's that?
Who's the beneficiary?
The lender.
The lender's beneficiary.
Which is the United States Department of Agriculture. Actually, it says the beneficiary is the United States of America, acting through the Rural Housing Service, or a successor agency, United States Department of Agriculture. Lender.
Yeah, and the banks are all using these trusts to their advantage because we don't.
Okay. All right, I'm with you. Hello?
Yes, yes.
Okay. All right. So I just pretty much got to read through here and find an enacting clause, basically?
Maybe. I was thinking that, that might take place upon default,
Okay. Don't security instruments have to be filed with, like, the same people that you'd file if you were selling stock? I forget the name of them.
They probably never will take and record that because that would be a UCC filing, and a UCC filing under a definition of Black's Law under trust receipt. Let me read you what the trust receipt definition says. Trust receipt under Black's Law, 8th edition, says that a pre-UCC security device now governed by Article 9 of the Code, and And skipping down, it says, today there must usually be a security agreement coupled with a filed financing statement. Well, if that's a trust receipt, then that's a record of a payment, really. And they don't want to record your record of a payment, so that's why they don't record these UCCs. Actually, if they did, that would be the proof that you had already paid it. So they don't do that. So now it's up to us to come back in and correct this misconstruement that this is all a debtor-creditor contract and with the security agreement and things, and then come back in with evidence otherwise that's going to prove by the records that it was our manifested intent that we, instead of this being a debtor-creditor relationship, it's now a trust relationship. And then we could do a recording of a UCC1 like we were talking about, and that becomes the trust receipt, the UCC3s and the 1s, as the record of payment.
Okay.
So what that does is the merger of the titles is taking through the expression of the trust, you're executing the trust, and it merges the titles and extinguishes the debt.
Okay. Because I was looking at this, and unlike every other trust I've seen, there's nothing here where the trustee would sign saying he accepts responsibility of trustee, or the grantor would sign saying he's granting anything to anybody. In fact, nothing in here that I've seen other than line 16 that says transfer of property or beneficial interest in borrower, if all or any part of the property or interest in it is leased for the term greater than 3 years, leased with an option to purchase, sold, or transferred, or if the beneficial interest in borrower is sold or transferred and borrower is not the natural person without lender's prior written consent, lender may, at its option, require immediate payment in full of sums acquired, secured by the security agreement. That's the only place I see where it speaks of a transfer, and the only thing that was signed was by signing below, borrower accepts and agrees to the terms and covenants contained in pages 1 through 6 of the security instrument and in any other rider executed by borrower and recorded with the security instrument. It's I think that's probably what's bothering me the most is there's no...
Is that a Texas property?
Yeah.
Is it? Okay.
Texas is a little weird, I know. So.
Well, it's still trust, and the trust is probably the real thing behind it all. So.
All right. Well, thank you. I'll let the other callers have a speaking.
Okay, thank you. Next caller.
Yeah,
Chris, you're unmuted.
Yeah, it's Chris again.
Yeah, go ahead.
Somebody had sent me something. I don't know if it was inside our group, but I thought it was pretty interesting to read. It's under equitable. Oh my God, I can't even read the top line there. Equitable remedies in modern English law. And under F, it says damages in lieu of injunctions. I thought everybody should at least have an opportunity to hear it. Under the Chancery Amendment of 1858, the court has jurisdiction to award damages in substitution for the awards of an injunction. Although the act itself has been repealed, their jurisdiction remains, and then it says copyright. In the general, the courts will only award damages in substitution in an exceptional circumstance, and then in quotes it says a good working rule as to when damages should be awarded in substitution was set out by Al Smith, L.J., and Schaefer versus City of London Electric Lighting Company. And then it goes into 4 different aspects below that. If the injury to the plaintiff's legal rights is, oh my God, I can't even hardly read it. Oh, excuse me, it's just so blurred you can barely read it. The rights is small, is what I'm just guessing it says. Number 2, and is one which is capable of being estimated in money. Number 3, and is one which can be adequately compensated, I guess is the way it says, by a small money payment. Number 4, in a case is which it would be oppressive to the defendant to grant an injunction. I thought that was a pretty good read right there in regards to what we're studying.
Equitable remedy, yeah. Injunctive relief.
Exactly. In other words, there is the public side, or at least that's what I'm gaining from this, is that there's a public side of which if you don't get remedy, you can always go to equitable side. That's what I got out of that.
Yeah, you've got exigent circumstances, yeah.
Here, locally in our local debtor-creditor group, we found an outstanding finding that I probably, once I get my hands on it, we've been talking about it this week, and we've got one person that's heading up summarizing our conclusions and findings this last week. But out of the Security Act and the National Banking Act, some of the information we gained this last week is that there are really only 2 true creditors that exist. And one of the true creditors is a person whom would be the signer of any of these agreements, which would most necessarily be the person that signs the signature. The only other party would be the U.S. Treasury / the IMF. All of the parties are debt collectors. And one of the outstanding facts that we found is that if you challenge them on a creditor level, is that they would be perjuring themselves if they claim themselves, or impersonating the U.S. Treasury if they claim themselves as a creditor.
Yeah, and I would make a correction that creditor is really grantor.
Yes. And in my input for this creditor-debtor group here locally is I told them that because the U.S. Treasury would be the true creditor, that you would be a co-trustee to that, not the grantor, but the co-trustee. So I've been trying to get them to understand and get them switched over to trust law and language, and slowly but surely I'm having that happen with them here locally. But it was interesting find to see that, because everybody that has been challenging the banks and or the attorneys in the courtroom on the idea that they're the creditor, most certainly will be admitting that they're impersonating the true creditor, which would be the U.S. Treasury.
Mm-hmm. Everybody wants to come in as secured party creditor. I think that's the debtor-creditor, but real creditor is grantor.
Yeah, and you know, I thought, I mean, it was just my thinking, because I'm still kind of putting this stuff together in my own head, that with this new piece of the information that there can only be 2 established creditors, that's the U.S. Treasury and us as the signers of these documents, that we can work that kind of language or that mentality into our documents.
Yeah, now why would the U.S. Treasury be classified as a creditor? Because we granted them our equitable.
Did we lose you?
I say, why would the Treasury be classified as a creditor? I'd say that's because we granted them our equitable assets.
Yeah, I would actually agree with that. And with trust law, if you stop and think about it, they're a party to the trust. And that means personally, when you put your signature on, they are supposed to be, or they're supposed to have your back, because that was the agreement that they had made to keep themselves out of prison for treason for putting us into bankruptcy to start with.
Yeah. So actually, if we granted them to be the holder of our assets, then they're actually trustee.
And that means that if they fail in any way to execute anything that would be our intent as co-trustee or co-grantor or settlor, if they fail to execute anything from our intent, then it could be construed that they're defrauding the trust themselves.
Yes, but here's the thing. We haven't expressed there to be a trust, haven't claimed there to be a trust, and therefore there is no trust in existence until we claim it. And
Even
they're not claiming
said,
it, so they don't have to prove it.
Yeah, but didn't you tell us, I mean, I've heard this several times, is that they don't have to tell the public or they don't have to tell every party that a trust has been created.
Right, right.
So in that respect, you're only under assumption that because of the Bankruptcy Act does pick trustees, that it is assumed that this is a trust because there's trustees or the language is there. Therefore, you're acting upon the assumption, or maybe clarification could be the other set of documents that you can create here, is to clarify whether or not there is a trust.
Yeah, but then we go out and we make documents and we make a payment out of this trust, but then they don't have to honor the documents because we never proved that there was a trust.
Yeah.
So it really comes back down to us again. When we express the trust and prove the trust, then now we have a right to utilize the funds in the trust and do an extinguishment of the debt or payment with it. But we've never done that yet.
It's based off of the local group that I was telling you about. They have came across, and I know that it may not be on trust law, and I keep telling them that we've got trust law, that I want you guys to get up and running with this stuff that supersedes all of this, but they have found a formula of which they say was the original intent of using the GSA forms with the IRS forms and the U.S. Treasury forms, that they have found a link of combining those three sets of documents that are a sure winner. And I told myself that, okay, when you get all done and you get, because they've got a lot of time invested on that, when you get done putting the paperwork together and getting that formula done, I want to start getting you trained with trust because it supersedes all of this stuff.
Yeah, yeah.
They're listening to me. Every time I can plug it in to get their attention on trust law, sooner or later I'm going to have them over here listening to these calls on a regular basis.
Okay.
So I've been working on it with the local researchers. But anyway, that's it for me right now. Thanks, I appreciate it.
Okay, Chris. Thank you. Okay, anybody else? Unknown, you're unmuted.
Oh,
Unknown,
sorry. Can you hear me?
Yes. Go ahead.
Hi, Christian. Shane, how's it going tonight?
Shane, hi.
All right. Pretty good myself. It's kind of hard to get into this groove thing. It's kind of heavy for me tonight. I guess I was a little bit tired. It's going to be one of those, got to listen to the call again tonight. Let's see, just to kind of, I think that was Chris there. He kind of got me peaked a little bit on some of the stuff he was talking there. Just off the top there, if we don't express the trust, they're still creating a trust and operating in one anyways. That's just one of those dynamic things about the trust, isn't it?
Right, but they're treating it as debtor-creditor.
Yeah. But that's just a cool thing. There's a trust there for them, and I just love that. I just love how dynamic this thing is because, they can just have fun with
knows it's the trust except us.
Yeah.
We're the one who created it.
Yeah, that's beautiful. It's a beautiful thing. It's just so, it's more fun than silly putty, I think. But, okay, getting back to, just to cover that. So, so there we go. The trust is always there. They just reconstrued it, and we don't know about it. Plus, they put themselves into probably like a beneficiary position. Do you figure? Just going over the old stuff, I think.
Right.
Okay. I can't really jump on too much of the stuff you said. Like I said, I got to go over it. But I had a conversation today So it's kind of a comment with an old friend of mine. We were talking about the old Sam Kennedy seminars that we're going to. He's a little bit more dedicated to Sam than I am. And we were talking about a time when we were standing and talking to Tom Schultz, because I think I kind of threw past you guys how Tom used to go in and collect, right?
Right.
So we had a super long conversation like you have, and we hadn't talked in a long time. And that came up, and and I was telling him about the trust stuff, and he was picking it up because he's got some good exposure himself, actually. And, excuse me, he was saying that what Tom was doing was he was going in, I think he was expressing himself as the grantor, and he was appointing the judge as a trustee, and then he said, was saying for something like, and finishing it off with something to the effect, now I didn't record a call or anything, but something to the effect of for settlement and payment and closure. And then after that he would ask, or I guess he'd probably instruct them, where can he collect his money. And I do believe that he even mentioned that they would one time or maybe often, that they pay him in jury vouchers. Just thought I'd throw that out there and share it with the group. Any comments on that?
Paid him in jury vouchers?
That's what my friend said. And I mean, he's like, yeah, Tom would talk to us, and he used to talk to him quite a bit, and he used to, he might even be listening, actually. It's not, I just gave him all your numbers. And he said, like, he even drove him a couple times to some of these court cases, because Tom would always show up, and he'd be like, oh, I got pulled over again, and they grabbed me, and, and somebody'd have to go and pick him up, and because, with his car and all this stuff. And, he mentioned this thing about, that's exactly what I said, jury vouchers. So I imagine it's some kind of negotiable instrument of some sort, and I figured he probably either, I guess it's something you can take to a bank.
Are there any values on them or anything?
It would be for, I'm imagining it was for the amount of whatever was created from the tickets, the original tickets that he got. And it's kind of consistent. I have had another friend of mine, but I'm not quite sure I believe him as much, but he stated that he once took a speeding ticket into a bank, and then they gave him a hard time, and he says in the story they called the police, and he actually knew how to talk to the police in such a manner that the police actually left at that point, and I think they said give him the money and tell him to get out. But not to disrespect the guy, but he didn't have any, not too much supporting evidence, but he's a very well-studied individual. So, but, and I guess the only reason why I mentioned that was because there was a little bit of consistency of the ticket being some kind of negotiable instrument itself, maybe. Mind you, what I like about, in Tom's case, I even though it's coming from my friends, that's two-party, I completely believe it, because that's the kind of guy that Tom was. And he did, if you were lucky enough to have the chance to talk to him, he just, kind of banged the story straight at you. At the time, though, this is going back to, let's see, when did we have that chance to talk to him? Was with, that was at the PTK thing, I think. He was there. He was one of the people there. So that's going back almost a year ago. Actually, his first time talking to me, just to add to the story, I guess, I was already driving home. I'd left at 4 in the morning. I'd forgotten something, and I drove back around 8 or 9, so I'd had no sleep the night before. And sure as fate would have it, Tom comes up, and he just started talking to me, and literally grabbed me because my friend was there, and he said, you don't understand this, and I am not letting you go until I explain this trust relationship. That was the first time I ever heard of a trust, and he was explaining it in terms of a three-party relationship, how there's a beneficiary, and he gave the example, like if a cop comes up to you, the cop's a trustee and you're the beneficiary, this kind of thing. And I was just kind of like, my head was spinning. I never heard of this stuff before, but just talking to my friend, I kind of brought it back, and he's quite well known that that's what he does. He's those tickets are money to him, and he goes into the courts. And so I got that he is the key parts. I guess that's quite confirming actually to what you're saying, is that he's the grantor, and then he appoints the judge's trustee. Which I've heard this before, but it's kind of nice to hear that it came from. That's being confirmed by this guy. You know, I don't know if people know Tom Schultz is very close to Sam Kennedy, and that's what he's doing. He said, and then he finishes. I think he maybe goes straight to the punch and just says, "I'm, here for settlement and payment and closure." I believe that's what he was saying. So that's something I want to share. I want to mention something else. Remember, I was telling you about a thing I was doing with Sears?
Yes, right. I remember.
Okay. Now, in a nutshell, it's there's about 10, 11 pages of me journalizing the entire last 7 or 8 months of how I'm trying to be patient with these folks. And I think I put in 2 notices, a revocation of consent. I should have pulled the letter up, and something else. And then I said, I'm charging you $300 a month and all this stuff. And, and I said, let me reiterate, this is what I expect you to do kind of letter. Like I'm, very, very upset with you people in as professional language as I could put it. And then one of my letters or statements I got had put the amount that they did kind of clean up my statement. They put the stuff on deferment, and then what little I had, a couple $100 on previous payments, went into some kind of a negative, went into a credit balance, and so I was owing 0, and I thought that is really weird. But that's not exactly what I asked, because they had taken some stuff off without my permission and put it onto my mom's account. I haven't followed it up because I don't know, it's just kind of seeing how many, wait until all their responses died out, because it wasn't going through the proper channels as per my notary acceptor, which was explained in the letter. And there was a self-authenticating agreement, I think, somewhere in one of the documents. I think, if I'm not mistaken, and I can't really say for sure, I'm going to have to wait a few more months, but I don't think I'm getting any kind of statement from them anymore.
And just leaving you alone. How long has it been?
That I haven't kept track, because I got so much mail coming in. I guess I should go back to my mail actually and double check it. It does maybe look like a month or 2 now. So like I just
did they give you any notice? Leave you alone?
No, because the last context I got was like, I shouldn't really say publicly, because I just heard it from another party that they were leaving messages on my answering machine saying like they wanted to follow up on a claim, my claim, like this, right? There could have been a series of calls, perhaps. But yeah, so, and what I'm thinking is, I'm looking at this kind of like I hate to say it, like a shark smells blood a little bit, because let's face it, right? They're not trying to do me any favors here. So, but although I know that the way these people act is like, they're trying to make it look like they are, but I have a feeling that if I'm that close, that I might be able to give them further instructions. You see what I'm saying? Because they did take all my credit. There was about $6,000 of credit on there. And one of their first moves when they were attacking was they tried to reduce all the credit that I had. Like when they moved stuff from my card to my mother's, I noticed they took away that credit as well, right? Like they're just doing nasty stuff. But I'm wondering maybe if I should go back in there and say, you know what, maybe this deserves a little bit of follow-up, perhaps. I don't know. I got to be careful though, right? But yeah, this wasn't.
With them so far?
I'm sorry?
Did you express a trust with them so far?
Well, see, what I'm getting at is that it kind of appears that I came dangerously close to it, and maybe that's why because there was still about $3,000 on that card, deferred and otherwise, And I don't think they just walked away from it for no reason. That's the question, I guess, right? And again, I kind of wrote that kind of Christian Walters. I don't know if I was listening to your stuff at the time or not. It wasn't on my mind. My mind was this revocation of power of attorney stuff. But I did put some notices in there. Again, I was just kind of operating intuitively. And I thought, well, I know customer service, so here you go, customer service letter and some notices. But actually, what am I doing? I'm creating all kinds of records, aren't I?
Right, right.
So, and there was no equivocating that I was asking for anything in these letters. I was like, man, 8-9 months of dickering around with all these smarties on their customer service line that's it. That's the end of it. And the last straw was when they vehemently lied to me, in my opinion, and they were saying these accounts have been adjusted. You won't be able to contact this person. You'll only be able to send them letters or email or something. And I said, get them on the phone. This is nonsense. And they did get on the phone, and it was these two open.
Here's the thing. I would say, most everybody tends to give up too early. They're happy and satisfied that they say stop coming at them, or they'll not bother them anyway. But yet they didn't get a payment receipt or a discharge notice or something. I would still keep coming at them, keep building a case for trust, and I would come at them for breach of trust until I got my special deposit back. All the proceeds there.
Okay, now your special deposit and all the proceeds therefrom. Now, what in my case, what would that be specifically? Now, what I had originally, just for context.
Well, let's say it was $5,000 in credit that your signature created. Okay, that's what they gave you. Well, you don't really know how much was created on your signature. And what's running in the background, that would be all the proceeds generated from your signature, which was put in the special deposit. Now, I would be getting them on a breach of when I demanded my special deposit back and they didn't return the special deposit, then I would be enforcing a breach upon them because I no longer want my signature back, plus I want all the interest that was generated in the background, that the proceeds from it, because that's my interest, not theirs.
Okay, that's almost like on a colorful level, going for some damages.
Yeah. And
I don't think I'll ever get all the
place to go and get that to get it enforced, because the onus probandi switches on the trustee. He's guilty.
Sorry, what was that word you said? Bonus probandi?
Yeah, onus probandi. Yeah, the burden of proof.
Onus probandi. Very interesting. Right, that would be the position to take. The burden of proof would be on them because they're the trustee if I properly express the trust.
Yeah, but the burden of proof is, hey, do you have a record of disbursement from the trust? If you don't, then you're in breach of trust. And the court of equity assumes that that's what the condition is, a breach of trust already. And they want to see your record of a disbursement. If there is none, they're going to sanction you and you're going to be in contempt of court.
Okay, I'm looking for a record of this. Now, but obviously now, as far as going back to making reference to the special deposit, are you saying I should still, I've got something established just with what I did, right? Basically a letter of what I consider a 10-page customer complaint letter in Word, to 10-point Word document. And then, of course, there was a couple pages basically which was instructions and notices, 2 notices, whatever, I forget what the second one, but one was a notice of revocation of
that validation. You did a debt validation.
Should just pull this thing up and look at it. But the let's see, where can I put it?
So you got a notice of breach.
Well, what I sent to them was, here we are, serious complaint letter. I guess it was this one. Yada, yada. So it goes to the CEO. I put the names of the...
Have you created any record of trust? Have you done any
No,
UCC?
no. I never. That's the thing. I guess I should I go back and do we might have something similar with our PPSA, our Personal Property Security Agreement, which I think is our equivalent to your UCC. And then again, I've done UCC documents in Texas and Michigan. But yeah, that's what I was going to ask you then. Do you think maybe for follow-up, go out there and go, hey, by the way, I want you to see, actually, that's a question. If I do UCC 1 and 3 again, do you show copies of that to the people that I'm dealing with, like this, when I send to the CEO?
Yeah, I'd be creating the evidence to prove the trust, which would be the UCC 1s in the counties and the 2 sets of 3s in the counties. That would be the removal from general deposit and the redeposit of the under special deposit. Now I've got the documents to prove trust. I would send them copies of that, and then I would make a demand for the trust res back, and when they fall down on that, then it would be a breach. I give them an opportunity to cure, and when they don't cure, then I come at them with a breach of trust.
Right, demand for the trust res, opportunity to cure, yeah, and then how would you do then after the opportunity to cure and probably some kind of notice of dishonor, then just what would be the follow up there? Just a demand.
Well, you could do a show cause hearing as why they should not be held in contempt of court for not doing what equity said. They could probably use that show cause hearing for an equitable hearing. That way I could come in and prove trust after I claimed that there was a trust and there was a breach.
That's it. Sorry, breach of trust. I missed that. Yeah, maybe. Yeah, that would be pretty. That would be a really. Now that's the kind of follow-up that I've been waiting for and thinking of, because that would just tack onto very nicely and be very consistent. And it's probably the very thing that
create records that a trust exists and give them notice of that. And so they'd have to have documentation. Then I'd have to give notice of the withdrawals and the redeposit. You know, that's been done. So, and I'd give them notice that there was a breach of trust and give them an opportunity to cure. When they didn't cure it, then I'd come in with a show cause hearing, bring in my evidence, prove that trust, and then here's the breach I'm enforcing. That's my claim. And now why shouldn't they be held in contempt? Because they didn't do the performance, they didn't do the discharge of the debt formally, and they didn't give me my special deposit back, along with all the proceeds therefrom. I want it back. It's mine. I have to get it from them.
A reasonable settlement might just be reestablishing the account and with a certain amount of credit on it.
Yeah, that may work too, yeah.
That probably is, that would be that's a worthy project. Exciting just thinking about that. All right, so yeah, that's basically, I just thought I'd throw that out there. But just, again, I like throwing out the story about Tom, about people who go into court and, for food for thought, that how we just, there's got to be ways you go into court and you can just, how you present yourself and your everything, the body language and your communication. And I guess
the only reason I want to go to court is to prove that the payment is extinguished. And where's my trust res? I want it back.
Well, yeah, I mean, that's right. He's not going in there like, I'm sure he's not going in there as the defendant. Like Tom is, I think when I asked him, I think he said he's been doing this for 20, 30 years, which surprised me because I just thought he was some guy who comes on Sam's call. But he's a real hardcore, like really hard guy on the outside, kind of Chicago, but the nicest guy you ever meet in the whole world. That's what he's all about. And so I believe he's going in there, and obviously not under duress, and probably to clarify, he's definitely not going in there like recognizing the judge and recognizing the charges and stuff. He's in there to collect.
fair game. I'm not going to go in there to challenge jurisdiction. I'm going in there to execute a trust.
Yeah, he's just basically going in there to say, where's my money? That's it. It's just, how do I collect? Like, what do you guys want to do here? That's kind of the impression that we're getting from the stories.
Yep.
You know? And so, like, Tom was, my other friend, sorry, I got another friend, Tom, who was the guy who drove him. Or I just shouldn't have mentioned that. You might get mad at me. But the friend who drove him, he literally had the honor because he was going to say, well, he was going to get to watch to see what was going to happen, right? That was a pretty lucky deal for him, actually. They had to drive some distance because, I forget where he's coming from. That particular case, though, he himself witnessed, and he's the guy who's talking to directly. He said the judge had no problem and said, for whatever reason, is it okay if we dealt with this by mail? So, in other words, I guess, there you go, hiding it from the public again, right?
Yeah.
So, and of course, I would trust them to send something like that in the mail, but who knows? So, anyways, I just threw that out there because I don't think he was creating any kind of documentation. And again, I really like to lean on the idea that there's stuff that we can do by our communication and physical standing in the courts, I guess.
Form an oral trust right then and there.
Yeah. It has to be there, right? It has to be there, whether it's presenting the birth certificate. I don't think he ever mentioned anything about that.
I would be going into court with the trust already formed, and I would be going in to enforce the trust.
Now, what do you mean with the trust already formed?
Enforce the trust, because the trust had already been formed.
Now, what do you mean exactly by that? In your intent?
The documents that you send me that haul me into court, that's my trust, and I've already turned that into trust res, and merged the titles, sent it back to you. Trustees already got res. I got the documents already created in my hand. When I walk into court, I'm there to prove the trust if necessary, but I'm there to collect on the trust res.
Okay, so he could have, that's an interesting question. We can actually get a hold of him because my friend has his contact. He might have signed it in a certain way as well. That there could have created it.
Endorsed it, you mean?
Sorry, yeah, I guess he would be authenticating or endorsing it, perhaps. He might be putting his authentication in a certain manner because you guys have to sign the tickets, right, when you get them.
Yeah, that would be the trust res. That would be the debt title that I would merge with an asset title and give it back to them, and I'd have documentation to prove that I transferred it already back to them, which would be the records to prove my manifestation of the trust intent and the purpose, and that the trust exists. And I'm ready in court right then and there to prove the trust, and where's my special deposit back that I demanded?
Yeah. Because obviously I'm sure he's bringing those tickets with him, and if they've got his.
Mr. Court, on notice here, I want a receipt for the extinguishment of the debt, or else you guys are in breach of trust right here and now.
Sure, he's got to be coming in on some kind of a powerful position to be doing this to a court. He showed up, and he's got the tickets with him, and he's coming in as the grantor.
And that's the only thing I'm going to be arguing, breach of trust.
Yeah. Oh, yeah. Yeah. Exactly.
No jurisdiction, no name games, nothing. I'm coming in on a breach of trust.
Yeah. Yeah. Oh, and I'm sure for him that would be a piece of cake. I'm sure they're going to try. I'm sure like maybe 100 people listening, X number of people are going to go and try doing something and get messed up really good. But yeah, I'm sure he'd just like batter down any attempts at jurisdiction or whatever. I'm sure they're going to try the name game. They will, obviously, without question. They're going to try and
yeah, we're not going to go 20 minutes on this hearing here. It's 3 times, Judge, and you're out on the 4th strike.
Yeah. Do you not understand?
You don't answer my question on the breach of the trust for the 4th time. This court's in dishonor and is in breach of trust.
Yeah, I love it. Yeah, I'd be saying that in the form of a do you understand? But yeah, exactly.
Do you understand, Your Honor, that this court will be in breach of trust on the 4th dishonor? 3 strikes, you're out.
I should write that, the 3-strike rule. On one more item I would add is I was telling you, like, on my driver's license I have with a all rights reserved per full column and the signature. And I went back to my favorite driver's license place, and I thought, you know what, I'm going to do it. I'm going to do it. And I was going to go in, and I was going to sign without prejudice, no recourse, for grantor, full column signature, which is, for me, as I've always done initials for my signature.
And there to get that all on?
Yeah, I can do it. They give me a little square, and I practiced on it, and I kept the square this time because this thing came up. Yeah, I put in just uppercase lettering above the square inside the little signature triangle, without prejudice, comma, no recourse, and then for grantor, full column, and my signature is actually my initials, always has been. And then I even was thinking putting, like I said, without prejudice, no recourse, for grantor, full colon, initial signature, for special deposit. Well, there was a screw up because I've done this so many times in the past when I was playing around with it and got my existing card right now says all rights reserved, on the slightly raised signature part on the driver's license, and all rights reserved per and my signature. Initials. But because I'd done it so many times, she put it through and she went, oh, you don't have to, I thought automatically I'd be asked to do the photo and the new application, and she went and put it through because I had to get it renewed. My date was coming up, and she put it through and she said, oh, we don't have to redo the application or the photo. Because if you do the photo, that's when you redo the signature, redo the card, and I think they redo the application form. So that part didn't come up. But I talked to the girls, and I said, oh, I wanted to do this. I wanted to sign it a certain way. And the mom wasn't there. There's a mom and daughter there. And the older ladies were jumping on me this time. They're going, oh, you can't do that now. And I said, what do you mean? I already got it on the card. And I said, you can't do that. They're starting this routine with me now. So they've gotten some instructions, and apparently they've been told now that I've been polite because, obviously there's no use arguing. I know from experience just don't argue too much, but I just said, well, I don't understand. How can you guys tell me how to put my name on a legal document, because isn't that kind of like a legal determination? You guys aren't making legal determination, are you? And all this kind of stuff. And then she said, well, no, we've been instructed that you're not allowed to put a title in the name. And I just sort of followed up and said, well, no, I'm not putting any titles on there. I'm just putting some conditions now, like the one I already have on this driver's license here, right? It says, all rights reserved isn't a title. That's a condition, right? Right? Is that right?
Yeah, right. Title and interest.
Right. What do you mean, right title and interest?
Oh, when they put a title down there, that's a right or a title or an interest.
Yeah, well, that's funny that she specifically said, and that word kind of caught in my head. You got to be careful how you interpret the word. She said you can't put a title. Now, I'm assuming that what
a title is an interest.
Yeah, but I wonder who's telling her that, and I think they're meaning like you can't put, let's say your birth certificate says John Smith. I guess what they're saying, you can't put doctor.
I don't want to put doctor or mister or trustee or trustor, grantor. They don't want you to put a title. No. A title is really, what they're really saying, we don't want you to express an interest. We don't want you to express a right.
Yeah, maybe, yeah. Like I think in that double-leveled language that they're speaking, that's kind of, I don't think it's an accident that the word she mentioned was title, right? And exactly. And they don't have a right to say that, because if they say that, doesn't that get back to what you were saying?
No, they're getting you to waive the right. They're getting you to waive the title. They're getting you to waive the interest.
Okay, but if they do that against my intent on the signature, isn't that a breach of trust on their part?
Well, that would be common law and be sent here, because that way, they're not operating that way because they're operating on the manifest intent being the record that you're creating at that time. That is your intent.
So how, on a practical level then, how would you go by that? Do I got to go up to higher levels? Because I know a friend of mine had
really, they have
an
no
issue.
right to you how to sign your name, or whether I'm going to put a restrictor or a qualifier or what I put on there.
Well, I know this is all de facto. I know that they're misinforming these people, and I know that they're making these people operate on denial plausibility, right?
They don't want you to express a trust.
Yeah, well, obviously, because I have noticed, by the way, just to throw in there again, not to brag or anything, but it's a very interesting experience. I've on 3 occasions that I've noticed. You know how when the police drive right up to your back end, and they're reading your license plate, right? One was I might have sped through just to get through a yellow really quick, and then bang, the guy was right on my tail line. You can't see that nighttime until you can see the cop car right there. Then they read the plate and drove off. And then another time I was turning into a side road. I never do proper stops. I always try to roll through stops and all that stuff. I just drive like they do. But again, guy chased me right up to a nice, nice quiet neighborhood, so it's so obvious you can see the cops zeroing right up on you. And then at the stop, I kind of stopped. I didn't do the proper stop right with the cop right behind me, and then I just drove through it. And then he didn't even follow me, man. I looked back, I just played real cool. And then when I finally turned to look in the mirror again, he was like way back there. And I thought, this is kind of cool. So that's why I thought I was going to ramp this thing up and add even more into it. Mind you, I like the all rights reserved, but I wanted to get the without prejudice. I don't, on one hand, if it's not broken, I don't want to fix it. And I do have that signature, that authentication established because it's already on there. But I just thought, the full out would have been without prejudice, no recourse, by grantor, signature for special deposit, because I think I hit everything bang, 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 right? Then that itself, when I get the copy, I've got the, that establishes the trust. Let's say I did do that in theory land. That establishes the trust. I've expressed the trust, and they, of course, will get a copy, or they're going to get the original signature one. I'm probably going to get the copy. But I've also, who's got the, that means that I'm still, am I in possessory title there? I've established a possessory title as the grantor because I've made special deposit. That could be my record right there, right?
Possessory title. You kind of lost me. What?
Well, like I said, I'm putting without prejudice, no recourse, by grantor, full column signature. And then after that, there's still room, and I put for special deposit. Then on the application form, I put that right underneath, and I was actually wondering if I should even do that on the signature card. Like, I don't know if I need to put for special deposit on the signature card, but on the application form, when they take your photo, I'll put for special deposit, because that's the application form. That's the, and maybe I can scribble out application at the top where they're not looking. But, yeah, is that not itself basically kind of preempting and saving myself some time? Because that's obviously, I have a copy of it, and they're taking it now, and they're going to be holding that in trust.
Yeah, so that was an actual fact that was done, but now you haven't created the records to manifest the intent, which would be trust intent.
So maybe I can follow that up with some kind of notices of...
yeah, the UCC and the counties.
Well, the for special deposit, isn't that the intent?
Yes, but you have no records of that manifestation because they got your originals, don't they?
They will have the original, and I'll have a copy.
Okay, but now you have no other records. You have no way of proving it. You need a UCC 1 and 3. And in this case, already wrote on the this was for a special deposit. Now you wouldn't need to do a withdrawal because you didn't do a general deposit. You did a special deposit, so it's not necessary to do 2 3s like we were doing before.
Right, right. I'm just making another. Do I need a UCC1 to claim that then?
Yeah, UCC1 claim it, and a
That's
UCC3
it.
transfer it, record, a notice that you transferred it. And then
Okay, so
monies.
Okay. Now, just curious though, why wouldn't the copy that I have of a document, which is their formal application, which I know that is kind of proof that I was there and I filled out their form and they have it on record. Why wouldn't that be?
Private document that you're holding. Where's your public notice?
Oh, it is that's right. This is all private between me and the License Bureau. Is that what you're saying?
Yeah.
Okay, thank you.
The ones in the counties are going to be the public notice of your private document, which is your copy that you got back from them or what you filed and gave to them.
Yeah. Then I'm making a public notice of what I just did. Okay, got you. That makes sense.
Public records that proves your intent. That's a manifestation of your intent that a trust was formed in the past.
Whoa. Okay. All right. That fits pretty nice, actually. That fits pretty nice. Okay. All right. I see what you're doing. And okay. So I need the UCC1, which is just basically making a claim on something I did, and then the UCC3.
Now, when you go to court time, and the judge says, well, you are the fiction, and well, what are you basing that on? Well, if I got a driver's license, a 1044, a birth certificate, and all this stuff, now I got the evidence to rebut. Each piece of those information is not what they are. They're not debtor-creditor contracts. They're trusts. Every one of them is a trust. I got the documents to prove it. Especially on the 1040 form, driver's license, Social Security, birth certificate, those, if I got those, I got counter evidence now to prove that these are all trusts, not debtor-creditor contracts.
Okay. Now, just to reiterate, you still feel, even if I put for special deposit on that form, and I got a UCC1 as notice of claim, you still feel I need that UCC3 to reiterate the special deposit again?
Yes.
Okay. All right. And I certainly don't.
That's the public notice now of what you did, which was giving them trust res.
But the UCC3 is the assignment, and
it's just public notice.
It's just another. It's a kind of a specialized form of the UCC1. But it's focusing more on the aspect of the special deposit.
Yeah, it's a colorable notice that they can see, and if they want to look at it as being an assignment, yes.
Okay, yeah, it just speaks about it again in the public or a public record of. Now those documents themselves, if I ever did have to bring those into court, those would have to be private for the judge, right?
Right. The private held documents would be in camera, judges only.
Okay. And now I can start talking like those guys who say, well, am I not to understand that this has this not already been settled in the private?
Yeah, extinguished.
Yeah, that's just, or you're asking for the name. If I give the name, I can do that thing, are you asking for the name? And if I give the name, is this for settlement and closure? Or I should even go farther, like you're saying, and for all the proceeds therefrom, that kind of stuff. I can start playing with that kind of stuff in essence, right?
Yeah, but now you have to get the terminology down to trust because it's a little bit different terminology.
Well, yeah, right. I don't want to use settlement, do I?
Yes,
merger. Oh, yes. Okay, got you. Right. Thank you for that.
Merger, extinguishment, and discharge.
Yeah. Merger, extinguishment, or discharge, right? Or disbursement?
Yeah, the titles have been merged, the debt has been extinguished, and the the claims and obligations have been discharged.
Okay, just extinguished and discharged.
Discharge would be a public term, merger, and would be a private name and word, and the, what was the other one?
Merged, just extinguished, and then duties and obligations discharged.
Yeah. Extinguishment, that's another private one.
Okay, and again, the bottom line is they have no right, and that would be consistent with another friend of mine who went to the passport office, and they tried the same things, telling him what he does is I believe he signs per or by or for, and then puts authorized representative. And they told him he couldn't do that, and then he said, bring somebody a little bit higher up, please, and they did. And then he asked him point blank, are you making a legal determination how I'm supposed to execute a legal document here in the province of Ontario? And they said, no, sir. And then he continued to fill it out. Now, the only problem I have with that is these little offices don't usually have any supervisors. You know, you might have to go to like Kingston. I know that's the place where they keep all the application records. That might be a main office there. But I might know them well enough that I could just say, listen, if you just allow me to do it, and I will keep you guys out of any liability issues. I'm taking on the full commercial liability myself, and I'll take it up with the government.
And indemnify them.
Oh, sorry?
Bring a bond with you and indemnify them.
Now, what kind of a type of bond would that kind of look like? How simple
just an indemnity bond, and you would just indemnify them from all liabilities, from whatever. So
that's an interesting concept. Yeah, something simple. Like here, I'll if you just fill this out, this show this is a bond that I'm making with you. I'm making a bond with them.
Yep.
That indemnifies them.
Yeah, we're making another trust.
And just saying, something to the effect of that I'm taking the full commercial liability. Should I say that?
Yeah, right.
For all my actions, and understand that the other party is just going to focus on processing, doing their main function of processing the documents.
Right. Yeah.
Without any, play it right back on them. Okay. That sounds pretty cool. So I got a couple things cut out. Well, by the way, what do you think of that? Without prejudice, as compared, I keep forgetting the difference. I know when you put without prejudice on something, I remember one of the key attributes very clearly in my mind was that document can't be used in a court of law. And I think all rights reserved, reserving all rights is also similar. I have a feeling it's similar because I have noticed that another party that's done it, we get really weird stuff happening. Like they give us a ticket on a day at an unusual time, like on a holiday, for example. And you just see a lot of weird things happen when we start playing with this stuff. So, they're playing games with us, and so we know that we must be hitting close. But yeah, I'm thinking within that context. Now, what do you think of personally, Christian? Just your personal take. Without prejudice, no recourse, by grantor. Full call on my initials, which is my signature, and then for a special deposit somewhere on the paper.
Yeah, so you would write by grantor if this was creating a trust. If you were making an additional special deposit and the trust was already created, then you'd be signing by trustee.
Well, yeah, this form, by the way, is a renewal. This is my 5-year renewal coming up. So And that's kind of an interesting term, isn't it? This is a renewing of whatever the previous contract. That's why I was a little bit thrown off when she went and put it through, and then she goes, "Oh, you don't got to sign anything, and we don't have to change your photo." And crap, that's right. I've been changing my photo card so many times. It was less than 6 months ago. So that threw me off.
Trust, though, right? First time you ever formed a trust. Correct?
Is this sorry? Your question is this the first time that I've expressed the trust explicitly?
Right.
And I would say, well, yes, in the sense that I only previously have on my signature card all rights reserved per full call.
That's going to set the way you sign the document, because if you're forming the trust, then you sign by grantor. If the trust has already been formed, if you're making a second deposit, then it's by trustee.
Makes sense. That makes sense. Now, and if I just put all rights reserved per the signature, that's not necessarily explicit enough. I should still, even if I was intending that it was established as a form of a trust, I should still just put grantor at least once at some stage of renewal or in between. So I still have to put by grantor because it hasn't specifically been put previously.
Right. Unless you're doing a modification of the trust as grantor because of a mistake.
Yeah, no, just to clarify the original intention.
Yeah.
That
Or
would
if
be
it was a second deposit, you'd be making a second deposit as trustee.
Makes perfect sense. That's a nice point to bring up. Okay, all right. I think I'll leave that right there. That was thanks a lot. That's. I hope that was intelligible for some folks out there.
Okay.
Thanks, Christian.
All right, Shane. Appreciate it. Okay, next caller. You're unmuted. Tammy.
Hi.
Tammy, you're unmuted.
Now that Shane's beat that issue to death, he should just go in like Tom Schultz and get a pair of balls and write on the damn thing by grantor, comma, SD, meaning special deposit, and keep it short and simple and know your shit, you know. That's how Tom Schultz operates. I've listened to him for a long time, and yeah, he knows bankruptcy laws, he knows trust, he knows all of it. He's been through the mill. But yeah, just tell them, damn motor vehicle people, are you making a legal determination on how I can sign my name? And make them answer. Say it again. Are you making a legal determination on how I can sign my name? Period. End of story. He's getting too stressed out about it. No offense, Shane, but been there, done that. It's easy. Just find your favorite girl and do that, okay? Okay. I just put AT&T on notice that they did breach of a trust on my internet advertising campaign. And what's really cool is I've read their microprint, tiny 5-page document, and it's totally tough verbiage. It's very cool. Intellectual property, and they talk about assignment. You may not resell, assign, transfer, or delegate any of your rights, duties, obligations without our prior blah, 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 on and on. But I love this part, my exclusive remedy. If we breach our obligation here under to fulfill any advertising product or breach, blah, blah, blah. So bottom line is, in 30 days, they were supposed to have created that internet site, and they didn't do it. So I sent a certified mail breach of trust yesterday. So it'll be interesting to see how that plays out. That was
breach of trust, opportunity to cure?
Yeah, I'll do that after I get a response of some kind of, hell, I couldn't even find a damn address to send it to. You know, you get this copy when they visit you at your home, and you know, you agree, and I signed as trustee because I am the trustee of the trust, and so we'll see how that pans out because, yeah, it's been, let's see, this was signed end of March, and they had 30 days, which would have been end of April, and now it's end of May, you know. And no contact. I can't get them to return my calls, so shit canning them. So it'll be interesting to see how that pans out, but, thanks, Chris, earlier for bringing up that National Republic Registry, and I'll re-listen to that as far as recording documents. And my Skype is Sind, which is Dennis, spelled backwards, my husband's name, Sind, TMM, my initials, TMM. And my friend Patty, that's good at creating websites and was going to create that site for posting documents, although at this point in time I don't know that we can go that route because of what you said earlier, Christian. But her Skype handle is Outlook, in other words, O-T-L-O-O-C, or actually if you spell it backwards, it's cool, two, or too cool, spelled forward, okay, it's confusing. So spelled backwards, hers is cool, C-O-O-L-T-O-O, or spelled forwards, it's O-O-T-L-O-O-C. Now that we're all confused, she wanted me to put that out there too, that's her.
Okay, for all those dyslexic people out there.
There you go, yeah, there you go. Yeah, we're both kind of looking for, you know, just like what I'm looking for is somebody to send me sample formats of the, well, I've got everything, NOI, SOI, what do you call it, protective order, all that good stuff. But I'm more looking for something that we're putting on a coupon for special deposit type thing. Just a sample. I got the basics figured out, but I know there's some samples out there, and I didn't get them before your website went down, Christian, and so I just thought I'd throw out my Skype handle again. It's Sind, TMM. So, anywho, that's all I had, but I'll have fun with that AT&T thing. We'll see how that pans out.
Okay.
But, yeah, I'm reading these Corpus Juris books, and, yeah, right dead on after reading about depositories and special deposits and a whole book on banks and banking. A whole book on banks and banking. So, yeah, it's pretty cool. I'm excited.
Is your sections the same as what I've been quoting, or are they different numbers?
They're different numbers, yeah. They are different.
Copyright dates are different.
Right, because of the years of the books. Yep, exactly. So I did have other concern if, you know, this National Republic Registry becomes a pain in the butt or we can't record on the website, but I'm going to check into that National Republic thing. But could a person stack, like let's say I wanted to record, say, my name, my husband's name, and my daughter's name, our notice of interest and statement of interest. I wouldn't want to commingle all three separate, you know, entities or persons' names on one UCC filing, but would it not be too improper to go UCC1, not UCC1, they won't take them, NOI, SOI on one name and record it and save the two separate filing fees, and therefore you got both your NOI and SOI recorded under one filing. Follow me?
Or say multiples of people?
Yeah, no, I want to keep the names separate because, in other words, if any one of us needed to use, you know, the documents, I'd want to be able to pull out a certified just showing a certified with the NOI and an SOI on each individual
person.
Yeah.
All right.
But couldn't one stack the NOI and SOI in one recording? I guess that's my basic question. I would think.
There's a trouble with the trust res. Was it transferred and before it was formed?
Okay.
You couldn't put it on one document because it would be also indicating a trust formation plus, you know, a transfer. So
right. So you'd want your two separate records separate.
Yeah.
Okay. That makes sense. Okay. We'll figure it out. But yeah, thanks again, Chris, for bringing that up, and I'll check out that National Republic. But that's all I had. Got my questions answered. Thanks, Christian. Sorry I missed the first hour, but good call.
Okay.
Thanks.
Thank you.
Shane, you'll figure it out. You got it. You just had too much caffeine or something tonight. Love you, man. All right, I'm out.
Okay, next caller. Jacob, you're on.
Yeah, hi, Christian. How you doing?
All right. How about you?
Just fine, thank you. This past week, I witnessed the police breaking into a person's apartment in Germany, and he was in there with his 2 children, and he was taking a stance, as in his standing from a debtor-creditor position, and I watched them. They broke the door down, and they hauled him off to jail. And these 2 little kids, just infants, went through all this stuff. And I realized that there's a lot of people that come to this call that you do, and they come from a debtor-creditor standpoint, and they think that they're going to have standing by coming up with all these ways that they have been receiving in their research and what have you. But when they go to apply it in real life, they find that the mindlessness of a police officer, that they don't understand the framework of language that is trying to be comported to. And so I tried to warn this gentleman that was going to happen to him, and he kind of didn't like me anymore because he had his stance in this debtor-creditor verbiage. And I told him that, when you get into a critical situation for your own safety, that these people out there, they are mindless and they are incompetent. And so it got me to thinking about our standing. And it got me to thinking about that if we're going to be a pillar and we're going to be able to make a stand and have standing in any place, especially in a courtroom, we're going to go into a standing of equity, that we need to know who we are and what our stance is, because it's like, should we not have standing as in the manner that the eyes that are upon us are enabled to see the strength of our standing? And so I thought about what we spoke about the guardian and the ward. And I started thinking that it appears that what they've done is they've misconstrued us into being this child, incompetent, mindless, okay? And so I did a little, I understand, it's my understanding that since the Rockefellers, they got the Dead Sea Scrolls 50 years before they released them to the public. They doctored them. They let them go out. It got the Catholic Church got backed into the 1992 Oslo Accord to be able to have their law form to come onto the Temple Mount here very soon, which will be under canon law. And it appears to me that we need to know where they're headed in law to not only understand where we have to make a standing today, but the direction in which we need to go for standing to have freedom. And so I looked at the canon law in relationship to what we had discussed last week, which I don't know if anybody understands what the canon law is or how it's applied to them. But under guardianship, they say that the condition or the fact of being a guardian, which is the office or position of guardian, that a person entrusted by law with the interest of another, inexperience, mental weakness, feebleness of will, disqualifies them for acting for themselves in the ordinary affairs of life, and who is hence known as the ward. And so I thought, man, this is what they do. If you go up there and stand, even if you have your records in order, and you are acting like a ward, I'm not sure that those type of people are going to be able to enter into equity. So the following couple paragraphs here, I'm hoping that you'll be able to shed some light, Christian, on this topic, okay? And so it says that the word guardian and ward are of like derivation. Warden is an older term for guardian. the verb toward, which we get our word toward, is derived from Old French, and it's warder, garter, garter, and one of the definitions of the noun ward is guardianship, and that is the control and care of a minor. And I think the minor is the ward in this case, which is inexperience, mental weakness, feebleness of will, and disqualifies him for acting for himself, and I would imagine in front of the judge. And so this control or care conferred by law is a substitute for an artificial extension of the parental power. The Roman law terms such control or care of a minor under the age of 14 years, tutelia, an authority and power over a free person, given and permitted by the civil law in order to protect one whose tender years prevent him defending himself. The civil law thus provided what the institutes, and they're talking about the institutes of Justinian in the 500s, also reenacted in Chicago in 1876, pronounced what the institutes pronounced agreeable to natural law. Tutors were so termed as being protectors of a person in the exercise of his rights. A tutor did not confer rights on his ward. The tutor's authority supplied the ward's deficiency for exercise of rights which he already had. When one person increased what another had so as to fill up the deficiency, this was called actoritas. Only one who was free could have that right, a deficiency in which, according to this explanation of its meaning, authority could supply. A slave could not be regarded as deficient for exercising rights because a slave, having no capacity to acquire the rights themselves, there could arise no question of his capacity to exercise them. Thus, a free person could only have occasion for a tutor or could be a ward. On the other hand, no person not vested with the rights of citizenship was qualified to become a tutor. So what I was seeing here is that your concept of taking care of the root so that we're not considered, incompetent in a ward when we have to have this standing in order to go into equity where we actually have conveyed our rights, or could we be construed as a ward by a number of things, our behavior, our language, the way our records are set up on our own personal being, and what have you. Do you kind of relate to what I'm trying to get the question of how we can assure ourselves, how do we assure ourselves of our standing when we get before a so-called judge, when we stand before a so-called public officer, police officer, or any public official, that our standing that we are sure of. So my question is how are we going to, do that?
Yeah, I totally agree with you. The guardian-ward relationship has to be terminated first to achieve standing, and the ward is really an infant being controlled by the court or the state.
But when there is a handoff, and I think the handoff is the handoff. Let's see here. The handoff is when you reach that majority of age that you were speaking about.
Yeah, age of majority.
Age of majority. Okay, it says the totilia of a male ended with his 14th year, of a female with her 12th. But a minor was not deemed of full age and fit to protect his or own interest while under the age of 25 years. And so on the discharge of the tutor, there was appointed a curator.
Right.
So, I mean, you could be a ward your whole life. The curator.
we still are classified wards, and we're still, say, 50, 80 years old. We're
Right.
still wards of the state.
Right. So my question is how are we going to, you know, it's one thing, I mean, it's one thing to understand how to tackle that. It's another thing to actually tackle it. It's another thing to get on the other side of the tackling and what have you. So everyone's going to be at different phases, I guess is my point.
Yes,
and so
because
I don't
age of the clock that determines majority age. It's not the age. It's not the time of the clock that determines the age of majority. It's not 18. It's not 21. It's not 25. What determines age of majority is when you come into the knowledge of knowing that you have the power to act or not act, and that is your discretion. That's the age of majority. So what we have to do is we just need to ask, or not ask them, we need to tell them we want a final accounting for settlement because we've reached the age of majority. We know who we are.
I like that, Christian.
It's not that I know that I am secured party creditor. No, that's not knowing who I am. Knowing who I am is I've reached the age of majority as grantor on this trust. I know who I am now. And that might be 40 years old or 70 years old, but sometime let's hope we all gain the age of majority.
Well, okay. So a person that's legally appointed to administer the property of another, which appears what most people's relationships are to the so-called their God, the state, who is unable to undertake its management himself, owing to the age or physical incompetence, bodily or mental. Curators are often confounded with tutors, but they differ in many respects. Tutors are appointed principally for the guardianship of persons and only secondarily for the care of property, while curators are deputed mainly and sometimes solely for temporal concerns and only incidentally as guardians of the persons. Besides, a tutor is appointed for minors, while a curator may have charge of the incompetent persons of any age. Finally, a tutor cannot be commissioned for a particular or determined duty, though a curator may receive such an appointment. So I'm just trying to get more clarification on this actually kind of rite of passage of our rights into getting to that age of majority where we can actually get that accounting and ask for that accounting and be, I guess, seen to be that age where they are required to give it to us. So how is it that we present ourselves to being that at whatever age that is? Because
when you know you can ask for it and you ask for it, you've achieved the age of majority. Today the tutor that is tutoring us under a guardian-ward relationship, the tutor is the statutes and codes, the public trust of statutes and codes. That is the tutor today.
Okay.
But when we reach the age of majority, that's when we come to the realization that we can ask for the final accounting and the termination of the guardian-ward relationship. That is the age of majority.
Now
and they must give you the account.
Okay, so please repeat. The tutor is the statutes and codes?
The tutor is the statutes and codes today.
And it's the public trust?
The public trust is the statutes and codes, yes.
Okay. So now who would be the curator?
The statutes and codes are acting as the tutor or the curator.
Both.
Both. Whoever the guardian is over the ward, that could also be classified as a tutor also.
Okay.
As a curator, excuse me.
Yeah, curator. Now, when the time of maturity comes, is it possible that we could be under the tutor, and then when we don't, or when we are incompetent or ignorant to know that we're supposed to make a transition into this passage of right, then maybe the term just changes to curator?
Possibly. Maybe they're using some other entity to be, synonymous with the same thing, but it's still the same relationship, I believe. Even though it might have a different label on it, whatever, it all comes back down to it's still a relation or a relationship to the trust, and we can still terminate it.
But is it possible we might need to terminate two, that they have made another one?
Yeah, but these are like issues of the leaves of the tree. I think it would come back down to the termination of the root.
The root. Okay, agreed. I got it. Okay, well, thanks a lot, Christian.
All right, that was a good question, though.
Okay.
But I'm trying to finish up what I started. It was last Saturday. I was reading that on the summary of the Guardian Award, and it wasn't done when I gave it out, and I haven't moved it along any farther. But what I want to do is I want to pretty much take this last 7 months that we've been doing under NTT and put it all in one summary. And it'll take in the Guardian Award, the termination account, the two types of deposits, and everything we've talked about more recently here, and like put it all in one document with a couple of graphs, diagrams.
It looks like to me what the guys that have been lifted up to have the world entrusted into their care right now, it looks as if they have taken this as a template to me, and they have transmuted it into a trustee guardianship ward type construct. We might be able to find some big secrets if we all work together and look at the transition period. I will be doing it on my own and will report in, because I think we're on to something here.
Yeah, but I think you're going to find out that it's like all these different leaves are all like the surface of a ball, but the branches that go in, they go down into the center, and the center is still the trust.
Well, but perhaps it's the master trust.
Yeah, but we don't want to get confused on all the different agencies on the outside surface of the ball, because that's really not what's controlling it. Somewhere there's like it comes down into maybe one that comes into the trust, and that's the main one. If you cut that off, then all the rest of them are going to be disconnected also. I think they've divided it and subdivided it and divided it again, and they've chopped it all up to where you're looking at all these little individual pieces, but yet you got to think of it all as one as a whole. And if we terminate whole, then it doesn't make any difference about the individual parts. They're all terminated also.
Okay.
I think the Guardian Award is the main one.
Oh, yeah. I can sense it in my spirit. Definitely the main one.
And that is really like the withdrawal and redeposit under special trust. That's the same thing, really. There's a duality there.
Well,
that's nothing more than merging titles also. It's all the same thing, really. It's just looking at it under a different face mask and viewing it differently, although it's the same thing. It's all merging titles, really. Whether we do a withdrawal or redeposit, that's merging titles. Whether we do a termination of the accounts and settlement and get the accounts, that's merging titles. I see everything being the same, just a different label of, a different label put on it.
Okay. You know, the most powerful thing that I know of is when one does a 40-day fast on water, and I've done many of them. And you start to die physically at about day 30, and for 10 days you experience dying. And it's sort of like if there's things inside of you that you cannot change, and the only way you can see a newness is by dying to the old. And then that new perspective comes in that last hour. And so maybe we need that when you talk about pulling up the root, maybe it's like somehow we kill the root.
Yeah, terminate it.
Somehow it dies.
We terminate it.
Mm-hmm. But for it to die. So often in ancient Hebrew writings, people would have a name change, and their old personality and character would be gone, and now they have this new name, and now they were looked at differently. And it's as if they died to their old self, and they had this new name given to them from above, and now they were basically had a new identity from above. And maybe there's some kind of thing in there, you know, that we have to die to our old identities.
Yeah, that's why I think we have to terminate the straw man.
Okay, Christian, thanks a lot for helping.
Okay, Jacob, appreciate it.
Mm-hmm. Bye-bye.
Next caller. Chris, you're up.
Christian, I want to ask you a question. Have you followed up some of the understandings about the UPU and having your own postal zone separate from the United States of America?
Yeah, that's like the easement, but I think that ties it into probably what we're going to be doing, maybe the same thing, but just maybe not calling it the same thing.
Okay, well, I had a long talk with Swift Arrow. I think you probably know who he is. He's the United Nations of Turtle Island. It didn't dawn on him until about 2 hours into my conversation to show him how powerful having your own postal zone really is. He has been conducting all of his sovereignty as a sovereign nation of the United Nations of Turtle Island as a symbiont relationship to the postal zone, the commercial postal zone called the United States of America. When it finally dawned on him that everything that he conducted as a sovereign nation was through his symbiont relationship with the United States of America's postal zone, it dawned on him that he's not truly free with his own zone, with his own easements, until he actually put claim to his postmaster and his own postal zone.
They're still under guardian ward.
Yeah, exactly. And when it dawned on him, he jumped off the call, and I went on to a different call. And about 45 minutes later, he called me back, jumping up and down, that he was so proud and so happy that he had secured a postal zone for United Nations of Turtle Island that extended from Canada all the way down to Argentina, and that he was exempt from symbiont relationship from the United States Corporation. Therefore, that included Canada and all the other postal zones that made the United Nations of Turtle Island subject to their jurisdiction. Therefore, he was able to secure his own law or his own activities that he conduct separate without having to answer to any other postal zone and their jurisdictions and their authorities. So I just wanted to kind of re-mention that, because I think that this is going to play a major, major component on where we're heading. Inevitably, I do see that this is coming down the pike. Keith Living Way is not the only one that has postal zones and acting as a postmaster. There are several other communities that are successfully doing this, and at some other point I can bring it up. But I did want to just kind of re-mention it because, you know, when you're looking at all this stuff about being a ward of the court and whatnot, a lot of this could go by very quickly if you became a postmaster under another postal zone separate from the United States of America.
Yeah, well, that was really talking about boundaries, and we talked about boundaries a couple of weeks ago, and boundaries was just one way of one method of identifying the identity of a person.
That's right.
But name was another one, and whether it was public or private was one of the other methods. But it was, the important thing was the identity. And boundary was just one way of identifying a person or a people.
And one of the things that intrigued me about what Keith Livingway had said about 3 or 4 months ago when I was participating with his call is that any time that you are looking to have a relations with another postal zone is that you call it for what it is in its identification, which is an easement. So when you're walking into a courtroom, instead of trespassing that courtroom, your paperwork and your easements reflect particular sets of language that allows you that diplomatic ambassador's channels to interface with that other postal zone, and that's what he was calling easements.
Right. So if we capture the name, we capture the public-private, and we capture the boundaries, we're going to go even farther.
Yeah.
Because that will control the identity, and we will be in control of the identity of the people.
That's exactly right. And if you're functioning from a postal zone that is exclusively separate from the postal zone called the United States of America and all of their parties thereafter, and you're a sovereign or you have claimed your free man or free liberties in totality, therefore you do not have to answer to their jurisdiction or their authority and or their codes and statutes, regulations, blah, blah, blah. And that was what really triggered Swift Arrow when I was telling him how important it was for him to get his own postal zone, because the driver's licenses and the passports and the visas and the registrations for vehicles was that important not to have a symbiote relationship with the United States of America. And once I had shown him, just by sitting down and talking to him about it, he couldn't wait to get off the phone. And apparently from what he was saying is that the UPU had been waiting for him to call, that they already had his paperwork already approved, and that's why he was able to establish and have that postal zone issued to him within 45 minutes.
Why, was he already in contact with them prior?
No, but they recognized him as a nation unto themselves without his own postal zone. Therefore, the UPU had acknowledged now he can conduct all his commercial business and everything else, everything he wants as a sovereign nation unto himself, separate from the United States. He no longer has any kind of a symbiont relationship with the United States of America at all. Therefore, he can set up his own doing business as United Nations of Turtle Island without any interference from the postal zone called the United States of America.
Yeah, how are they keeping track of what areas they've doled out already?
I haven't been that close to it, although I do really care for Swift Arrow with the United Nations of Turtle Island. There's a lot of hot pokers in the fire right now, and, you know, I can see down the pike that the postal zone was one of the major, most important things for him to understand. Now he has it. Now I'm assured with my driver's license and my registration that I am completely exempt with my registration driver's license from the United States of America. I have no symbiont relationship because all of my driver's licenses, my passports, my registrations for my vehicles are under the postal zone called the United Nations of Turtle Island.
Okay, I'm going to throw this out. How about instead of going forward and moving towards that, why don't we go backwards, and we go backwards to, say, 1776? What are the boundaries at that time?
That's very interesting. In my quest and my completion with the land patent, I have those easements in language that I can send you that will intrigue you. The language that was written at that point as the meets and bounds for what they put in language at that time. I've got that language because I put my land patents based off of the original Indian claims on the land prior to the jurisdiction of the United States Corporation on the lands.
Right, so if we want to claim 1776 law form, it may be the boundary definitions during that time also. You know, since they came and did the Buck Act with the zip codes and overlaid everything else with this new way of determining the boundaries, which would completely take us out of our old jurisdiction.
Did I happen to tell you that the Zoning and Planning Commission is owned by a private corporation in Denmark or Switzerland, one of those two countries, and that it was implemented onto our society and it's foreign to the United States? Therefore, it was never ratified or lawfully brought in as a lawful part of our government. Did you catch wind of that?
No, I didn't, no.
Yeah, I just kind of like, whoa. That's the reasons why Keith was so big on doing the rural routes, is because it superseded the Zoning and Planning Commission, of which is just another corporation doing business that's owned by another corporation outside of this United States of America that have their foot in the door to make profits off of every deal that's struck on the commercial side of this country and all the properties and zip codes. It's pretty amazing how major of a web these corporations for profit has really infiltrated our society. Just amazing. But
and we need a whole paradigm shift to get out of this debtor creditor mode, which is credit, and using it as money, because it is really the downfall, I believe.
Yeah, I totally agree with you. But I didn't mean to get us off subject matter about trust and whatnot. But somewhere down the pike, I can really see that there's going to be an importance about the the postal zone and having a direct relationship with the UPU. Now, this gentleman, which seems to be the key component that even supersedes Keith Livingway and what Keith Livingway is doing, is Jim McBride. And I've been kind of hanging out looking at some of these documents, and our group out here, one of our groups out here, is moving very seriously with that. Apparently, once you become a postmaster as an individual under the treaties that Jim McBride has cranked out, is that you act as an appellate judge for your local communities. And so, therefore, anything that you say flies, no matter what order or instructions you give to your local jurisdiction. Whatever you give, it's mandated they have to respond to it in that manner. I don't know everything about it, so I can't explain any more than that, but it has been explained that you got 3 postmasters within a certain parameter of space. They have the abilities to outweigh any de facto form of government appellate court on any issue. So there's strengths that are out there that are starting to show me that I wanted to just point it out real quick to you before the call gets over, that maybe you might want to just keep it in the back of your mind that there's other things that could fit right into our program that we're doing here.
Yeah, I'm aware of that, yeah.
Okay. All right. So,
How's
yeah,
that fit in with tie-in with the authority over the provost marshals?
that too. I just wanted to let you know that our grand jury out here finally did ratify. We're up and running for California now, which is a good thing. We were one of the last ones that needed to do that ratification, but I think there's only one other state, and it probably is done by now. But we've got all 50 states up and running now with grand juries.
Is that under the Restore America thing?
Yeah. And there was word the other night that there is the relations starting to build between the Tea Party group, top people, and also the 912ers. So it looks like everything's right on course. It has been said that we're right on course. And
how about the buildup for the 4 brigades of Russian troops and the UN troops that are moving in the California area and probably other areas to probably do a put down of the coup attempt that's probably they're going to classify it as, even though they're going to say they're trying to do the Restore America peaceably, but I can see a buildup of where they may be trying to take these people out. What are they doing in preparation for that?
Well, there has been a calming of that, and on the private calls for the grand juries is that we have over 90% of the military backing us on this stuff. And you have to lend yourself because you can't be in these intricate situations, but the coordinators, state and national, are very serious about this, and when they say we've got the backing of 90% of the military, you kind of got to lend yourself to that. I have no...
That would be the only last bastion of defense, I'd say, to protect foreign troops from being on this country and taking it over by force and classifying what we're trying to do as a coup. Because these UN troops and that are probably, got to be working for the U.S. and the U.S. is sending the 101 out to Afghanistan and everything and getting rid of all the people who can defend it. So, well, I just hope there's enough troops here to protect the homeland.
Well, I think that it may be non-military is what I'm thinking. I don't know all the ingredients because, I've got like 4 or 5 different pokers really going on here, and that's just one of them. And I just wanted to let you know that the grand juries for all 50 states have been completed. So.
Well, I thought I'd throw that out there since you could maybe pass it on down the line and see what,
I will. I actually will because I'm up the state. I'm inside lane on that one too. So, but that's it for me for right now. I'll let you get back to your Q&A.
Okay.
Thanks. I appreciate it.
Anonymous, you're unmuted.
Thank you. Thank you, Kristen.
Hi.
How's everybody going?
Getting kind of tired tonight.
Yeah, it's a Saturday. Semper Fi, everybody. Semper Fi. And I've got an easy question for you, Kristen. I'm going to put you right in the middle of it. Let's say you're this dope named Abbott, and Abbott's going to go and protest his taxes in front of a live audience. What would be the best approach to the idiots that you have to speak to?
What is the public affair that he's going to?
It's the house taxes that everybody has to go through once a year. Oh, what was your question?
Yeah, you said he's going to a public thing and he's going to protest. You said what is it that he's going to?
Oh, what it is I'm sure in every major city they tax the houses and they give you an opportunity to state your case in front of, say, 4 people chosen to tax you anyway. But what I was asking is, I want to express the trust right there because it's recorded, and I wanted to do it in such a way that I put them all on notice, and at the same time, most of them probably won't understand, but I'm just trying to find out a method to do this, and I know expression of the trust orally is one way. That's one formation. But I was just wondering what, let's say, Kristen would do.
Well, I'd kind of reiterate what I talked about Shane about there. I would come in to execute the trust, which would be, the trust has already been expressed, it's already got the records formed, and I'm just there to make sure, where's my deposit at because I've requested it back. And if they're not going to give it to me back there, then that's an enforcement of a breach then. And that's the only reason why I'm at this hearing or at this court or whatever it is, because everything's really all been done prior to me going there.
Okay, even though, like you have stated before, that all of us have signed documents that really put us in debtor creditor, you can still state it that way?
Yeah, but I'm not so much to tell them about what's going on. I'm there to collect on my special deposit, and if they don't have my special deposit, they're in breach. I've already I've expressed the trust before. I've got the records to prove that there's a trust. If need be, I can give them the records then. But I want to know where my deposit is. Where's my special deposit? Because that's what I'm looking for. Was it applied to the extinguishment of the debt, and where's the rest of the proceeds from it? Because if they don't have my deposit, then they're in breach of trust. I'm there for enforcement of the breach of trust.
So basically, we're asking for a pin back, right?
Yes, yes. I want my pin back.
Okay, Kristen.
That's it. Right on the head. Right on the head. Yeah.
You've had a darn good call, man. I learned a lot from you and from the people asking the questions, and whatever is going on out there, we've got someone bigger, someone that is waiting for us to talk to him. So those that think that way, they should, because I don't think we stand a chance if we try to do it any other way. But
united we stand, divided we fall.
Yeah, exactly.
Okay, thanks, Albert.
And Kristen, you have a good 3 long days. Are you going to take Memorial off, or are you going to be on the call?
No, I'll be working. It's too valuable to let go. We got to keep on.
Okay, Semper Fi, Kristen. I'll see you later, brother.
All right, thank you. Carlos, you're unmuted.
Am I muted?
Yes.
Okay.
How are you, Carlos?
Good evening, everybody. Good. Quick question. I'm working on my business trust. Okay. I'm getting rid of my LLC. I want to do everything under trust. Now, is there such a thing, or how could I add some wording or anything that I could do to try to make my trust impenetrable, or is there such thing that's making it impenetrable, like some guys claim?
Well, I don't know. Are you trying to generate a profit, generate an income?
Yes, this trust is going to have 15 properties in there, and it's going to be a business trust, and I need it for asset protection and keep it away from the private view and that's the owner of everything. That's the owner of all the land trust that I have on the property. Now I want to make one master trust, which it's gonna be the business trust, and it's gonna have a EIN number. It's gonna file everything like a normal business would do, but I need to put any wording, any indenture that would make it basically harder to get to or penetrate or pierce the veil.
Right.
Anything? Any ideas?
Well, I don't know. I'd have to think about whether I want to form a business trust and put all my other sub-trusts in that business trust, because that would make maybe them all public and accessible.
Well, yeah. Okay.
Income and taxes, and I'd be doing be connecting myself with a U.S. business or trade again.
Yeah, no, that's what I'm trying to stay away from.
All right.
But let's just separate them. Let's concentrate in one property, one business trust, owning one land only owning one land trust. How do I make that business trust impenetrable so that they can add garnish or put a lien? I know they won't be able to put a lien, but penetrate it to see what's inside. Any wording?
I would think you'd probably have to terminate the master trust, the straw man, and do like we did on that 126 call.
Yes. Yeah. Well, they would have to penetrate the business trust, which is the / the master trust. They would have to penetrate that, and then they would have to find out about the land trust and whatever it owns, and and who is the beneficiary, and they're going to have to compel the beneficiary. The trustee, and they would have to compel the trustee to produce the beneficiary. But my main point is, I want to try to make my main trust or the master trust impenetrable, if it's possible, or is there such a thing?
Well, I think the only way to make it unpenetrable is don't do any business or trade by generating a profit. Just be a consumer.
Okay, great. Yeah, you gave me a good idea. Great. Yeah, okay. Thank you, Christian. That's all.
Okay, anybody else? Okay, Jacob, you're up.
Oh, thank you. I have a question about mortgages, and it has to do, though, with the 65 million people out there that a lot of them are not in so-called trouble with payments and everything. And so, and also people that have had a house that they have sold that they didn't get their promissory note back from. Have you thought through how to? I mean, those two groups we've never addressed, and I've run into about 20 or 30 of them this week asking me stuff. And so, I guess the most important one is if somebody sold a property and they didn't get their promissory note back, can you express a trust? If the trust still exists and the promissory note exists?
Yeah, the trust is there on a private, say, but you never express it. It can't be seen in the public, so therefore it doesn't exist in the public until you express it.
So if a property is sold and they didn't return the promissory note, you can still express the trust and then order it back?
Yeah.
And what in that it's a non-negotiable scenario, how do you handle the negotiability aspect that you want to convert?
Well, it's been kept non-commingled. That's non-negotiable. Unless they commingled it and then they breached the trust. But if they securitize it, probably non-commingled, it's being held in trust.
Well, it's got to be commingled.
No, it doesn't.
No?
No. If it's securitized, it's not commingled.
Okay, so So the enforcement aspect of it then, if it's not commingled, then this would be a breach if they didn't return it?
Correct. Yeah, I think they're taking good care of our special deposits because they know they're special deposits.
Right.
Except that we never knew they were special deposits. Therefore, they don't have to treat them as special deposits until we claim it's a trust and they are special deposits. That's the only thing we haven't done yet. Now you can do the enforcement on a breach of trust by calling the note back when they don't give it back, breach of trust.
Is the note still in play?
Yeah, because it's somewhere in some trust, someplace probably.
I mean, but it's deriving payment or interest.
Yes, because it's been securitized in a pool.
Right. So what is the value of it, the original value, where it was given as general deposit?
Yeah, that would be the value that you gave it. Yes.
So also what will happen to the escrow account with the payments against it as well?
Some investor probably got that, and you never claimed that either.
So that's another part of the proceeds that you never got back also.
Yeah, and who knows what they've done on your signature on the note, whatever bonds and stuff they've done in the background. It's all yours to do.
Okay. So on the other hand, the other people that are going underwater right now, what is the most effective strategy that we could consider helping that party?
The ones that are in foreclosure now?
No. They're not in foreclosure. There's a big movement in the U.S. right now, huge.
You say they're underwater? You say they're underwater?
Yeah. The underwater people are, trying to do loan mods or short sales, or in many cases they're actually in California right now in herds. They're walking away from their homes.
You mean they're upside down?
Yeah, and they're not waiting for foreclosure. They're just bailing out, or the other half of them are, trying to get a loan mod or do a short sale to bail out. And they're not in foreclosure. They're up to date on their payments. They have money.
And they're not upside down. They're not upside down then.
No, they're upside down, of course.
Well, if they're upside down,
not in payments, but in equity. They're upside down in equity. In other words, they owe X amount of more than what the property is valued at. They're underwater in that respect.
Okay, so that's upside down then. Yeah, all right. But then the next step is they'll be in foreclosure then if they're not making their payments. Then.
No, but they're making their payments.
They're making their payments. Okay. So what can they do?
Yeah, what can they do if they're making their payments but they're upside down?
Same thing as what we've been talking about all along. Express the trust, execute the trust, come back in and get the special deposit back. If they don't, could breach the trust and go and enforce it.
Okay. That's what I was thinking, but I was just wondering if you had any other insights to that strategy.
No, it's the same whether you're upside down, inside out, where you did make the payments or where you didn't make the payments. It's all the same stuff.
They got it, boss. Understood. Thank you kindly.
All a trust, and it just needs to be expressed and enforced.
No, that's what I thought. I just wanted to get your feedback, so I always like to have a witness.
Okay.
Thank you.
Well, we've got about 4 minutes left. Anybody else? Five 6-1. You're unmuted.
Yeah. Hi. This is Fritz in Florida. I was wondering, maybe since the only one that can foreclose on anybody is HUD, maybe we should do something to ask them or put a claim into them for the interest, the promissory note, and the return of all that. Since nobody else can really foreclose but HUD.
How about Fannie?
Go ahead. I'm sorry.
How about Fannie Mae?
I think HUD is the only one that can actually pull a foreclosure.
Yeah. A lot of foreclosures going on that don't have HUD's name on it, but anyway, maybe the HUD's in the background. But
right, that's what I'm saying. If they would have that statement or whatever it is, I don't have it, but that's what I've heard.
So what can we do? You mean, or just?
No, notice them that that they've never gotten any foreclosure notice from HUD, so their notice for foreclosure and everything is invalid, and anybody that would come against them is trespass, either on trespass or theft of property, until everybody can get their easements and their land patents and the rest done, and their postal zone codes.
Yeah, but you'd have to make some kind of claim in court and get some kind of injunction to stop the foreclosures or whatever and be able to prove.
Right. They go ahead of time and put that notice out there, or put that claim in and instruct HUD to return their promissory note and the interest, and do the opportunity to cure and default, and make a claim on that, and what the value or whatever the interest, ask them for a statement of accounting.
Yeah, you could do that. But I don't know if they're holding the notes, though.
Probably not, but maybe like that zoning and planning department, they're getting a fee or something out of it.
Well, the only place you got is the party that you did business with was supposedly the originator, the lender, and that's the starting point. So that's where you got to start.
Right, but I think that they only get their authority through HUD.
Well, that may be through subrogation or whatever, but it all started with that lender originator, and that's where you got to start too. That's where you claim the trust and prove the trust and demand the note back.
Amen. I think the only one that can recall your or revoke your driver's license is the Secretary of Transportation.
I think the only one who can revoke your driver's license is you.
Well, yeah, there you go. That also.
We created everything. We're the only ones who can revoke and terminate it.
Amen. Just a little food for thought. See you soon.
Thanks, Frank. All right, I'm going to call it a night, folks. Why don't we end the Q&A, and we'll see you all Monday. Be on at 10 o'clock on the Ambassador's Call.
Q&A session is over.
Okay, if anybody wants to go ahead and talk, you have to unmute yourself, but everybody have a great weekend.
Unmuted.